Good morning, everybody. What is it, Thursday? That sounds right. Happy Thursday. Welcome to the Courtroom Files Live. Good to have you here. We're going to start our day in the 44th District Court, Royal Oak, Michigan. This is Magistrate Donald Chisholm. It's a very quiet start to the morning, but we'll spend a few minutes here to see what's going on.
Trying to go in a yellow light. Sorry and apologize for that one. I'll not do it again. Never, sir. Please, it's my humble request. I beg you, sir, please don't give me point.
Is there anything you want to add to this, officer?
No, Your Honor.
Mr. Nessum, the points don't come from the court. The points come from the Secretary of State. They have no control of the points. The points for any given infraction are exactly and only what the Secretary of State says they are. Now, in this matter, based on your driving record, I can tell you that the Secretary of State is going to send you a letter that will tell you how to take an online traffic safety class to keep the points from going on to your record. It doesn't take the points off. It stops the points from ever going on. It's a once-in-a-lifetime opportunity.
Yes, sir.
For a driver with a good record who is cited with a civil infraction that carries 3 or less points, not including careless driving. So do you still live on Lorraine?
Yes, sir.
That's the address to which the Secretary of State is going to send a letter. Now, on this matter, the court's consequences amount to a fine, and the fine is $130. That can be paid online or by mail, or you, if you chose, you could pay it at the courthouse counter. Now, if the Secretary of State's a little slow in sending you the letter, that's not a problem to you because they will not give you the points until you've had the chance to take the class. And I want to repeat, the class doesn't take the points off. It stops the points from ever going on. So what's your mail from the Secretary of State, because it's going to be good news.
Okay, sir. Thank you, sir.
Thank you.
And
Have a good day.
so when I need to pay, sir?
Well, if you were standing in the courtroom, I'd say you can pay as you leave, but what kind of time do you need?
I'm at home at this moment, sir.
Right.
So if you give me like a 1 or 2 weeks time, it will be nice for me.
Sure, we can go 2 weeks.
Okay, sir.
There you go. 2 weeks to pay. You are good to go, sir. Have a good day.
Thank you, sir. Bye.
Good morning once again, everybody. Happy Friday Eve. Welcome to TCF Live. Looking for other courts to come online. We're going to hang with the magistrate here for just a few minutes. He's not exactly known as Mr. Spicy or anything, but he's a place to start. I'm seeing a lot of courts just starting to boot up now, so we'll have some really cool stuff for you here shortly. And I would direct you to the pinned chat In the Blind with Mike and Dan, our pilot episode, our premiere episode, right after the show today. So be sure to stick around for that.
Trial. Do you still live on Aberdeen?
Yes.
And I don't show a phone number for you.
313-515.
Thank you. She's requesting appointed counsel.
Yes, Your Honor.
So you'll stay on with Mr. Manoogian. And Esteban, Mr. Manoogian.
Your Honor, Ms. Johnson is 18 years old. She has a driver's license. It's just suspended, and it's only suspended because of the one ticket in 34th District Court. She's going to have that ticket cleared up by her pretrial date, and she'll have a valid license by then. She's appearing on Zoom this morning with her father. I spoke with both of them. She was attending school at Grand Valley State and is on a break from that. And I would just ask that a personal bond be set.
Ms. Johnson, the purpose of a bond is not to punish somebody before the trial. It's to make sure that they get to the trial and to ensure the safety of the public pending. Your attorney here has indicated that by the time of the pretrial, you should have things all in order with the Secretary of State. But even if you don't, let's say something turns to mud, don't skip the pretrial, because then there's a warrant issued for your arrest. So
Okay,
just don't do that. Show up no matter what.
okay,
The bond in this matter will be $2,500 personal. You don't need to pay money to stay out of jail till the trial. It's a personal bond. In the event you don't appear, or in the event you violate the statutory terms and conditions of the bond, then in that event you could owe the money, but that is very remote. All you need to do is don't drive without a license and show up on time. The next hearing, the pretrial, will be a Zoom hearing, but it won't use the same set of Zoom numbers that you're using today. So when you get the notice in the mail for the date and time, they will include the new Zoom contact information for that hearing.
okay, thank you.
Okay. Good luck.
Thank you, Your Honor.
Thank you.
All right, friends, we're going to stay in the 44th, but Judge Meineke is just getting started, so let's go over there.
A dog-related case that was taken under a delayed sentence to potentially have the case be dismissed. The only thing that I needed to confirm, I haven't heard that there were any other issues with the animal in question. I just had to confirm whether or not the $200 has been paid. Did you pay that, Ms. Godin?
Yes, I paid it. It was either last week or the week before.
All right, can you check that out?
I hope you ain't had nobody called in on you.
Well, we'll be able to verify that, okay? So we're just checking on it right now. The most recent update that I had still had a $200 balance, but that was last week or so. It is, my staff just verified it's a zero balance. Okay. All right, so this should be a very simple, straightforward hearing. I will note that you have complied with all terms, and based on your compliance, the case is dismissed and the file is closed. So good luck going forward. Hope you have no further issues like this, and good luck to you.
Thank you so much. I appreciate it.
All right, Norman Jackson is here for a review. Let's take a look here. 2501221, Mr. Jackson, can you state your name?
Norman Leroy Jackson.
All right. Jackson, how are you doing?
I'm all right.
All right, so when I saw Mr. Jackson, I adjourned this out. Said that I would suspend jail and just give fines and costs on this, as long as he didn't pick up any new criminal charges. And we're set for a review today. Interesting, we set this, I asked to set it for a review in 6 months, we're back here in 4 months. But Mr. Jackson, I'm looking at your criminal record. It doesn't look like you picked up any new charges, is that right?
Right.
You haven't been in any other trouble, right?
No.
Good job, Mr. Jackson. All that's left is that you owe $250. Are you working now?
No.
All right, where are you staying?
I'm staying with my mother. I'm disabled.
Okay, all right. Is mom there with you?
No.
Okay.
His other guardian, I'm his sister. I'm here.
Oh, great. Okay. So, so for 4 months, originally I wanted this to be set out 6 months. For some reason, my staff put it up at 4 months. But because he showed up today and because he hasn't picked up any new criminal charges, the only part of this that's left is the $250. But I'm going to make one more offer to Mr. Jackson. If he can continue to stay out of trouble for another 2 months, since again, my original plan was 6 months, all right? We're just here a little early. If he can stay out of trouble for another 2 months, then I'll waive his fines and costs. And he doesn't have to worry about trying to figure out how to get $250 when he's disabled. Do you understand that, Mr. Jackson?
Yeah.
Can you keep
Yes.
staying out of trouble?
Yes.
All right, so ma'am, you're his guardian, are you hearing what the court's saying here? As long as he stays out of trouble, that $250 that is still outstanding, I'll waive that for him?
Yes, sir.
Okay. So I appreciate you looking out for Mr. Jackson. I'm glad Mr. Jackson is staying out of trouble. Stay away from alcohol. Doesn't do anything for you but get you in trouble, right?
Right.
So I will adjourn this for 60 days. If no new criminal contact, and waive the $250 and close the file. All right, I think we got a plan there. All right, that way I can save him some money and he can continue to stay out of trouble. All right, we'll keep it simple. Thank you, ma'am. Good luck, Mr. Jackson.
All right. Thank you.
We'll send a notice in the mail. We're gonna still send it to the 13-mile address, right?
Yeah.
All right,
Yeah.
good luck, sir.
Okay, friends. Again, court's starting to come online now. Let's stay in Michigan, but let's say good morning to Brian Oakley.
All right, Mr.
Line.
What's that?
You were able to steer my client Zing right in line as cooperating with the probation department.
Good, good. Is he the guy that was just blotto the first time you brought him in here? Yeah, he's been doing really well. Oh, this is the guy that we couldn't get a hold of. Yeah,
Both of them are.
good, good.
Morning, Your Honor, for the record, on behalf of the defendant, Your Honor, there is a plea agreement in the file that my client was being responsible for the double.
Yep.
$500 fine.
All right, we'll do the double parking on the civil infraction. All right, Miss Gamble, is that your understanding of the agreement? You've agreed to pay $500. All right, I will accept that plea. I'll dismiss both the original charges. Can you pay the $500 today? Yeah, but understand that we don't do all this disposition until we get our money. So if we don't get the money within that due date, you're back dealing with all this. All right. So I can do you 30 days. Can you remember that? All right. So I'm not going to send you downstairs to do any paperwork downstairs. Just you get that paid within 30 days.
Thank you, Your Honor.
All right. Good luck. Always.
For Sumter, is it the new guy or is it not?
Both are here. Oh, that's right. People versus Miracles. Morning, Council.
Morning, Your Honor, Joseph Hall, appearing before, and on behalf of here, this now standing to my
Morning.
left, Spirit, if you can say your name on the record. And Your Honor, I believe we do have a resolution contained in the file executed by my client, whereby he is going to plead guilty to one count of driving while license suspended. In exchange for that, the companion case is going to be dismissed. And as to the DWLS, the ticket along with that DWLS
Speeding.
is already defaulted and it's going to, and I believe it's written up according.
So you're asking me to set aside the default and dismiss?
Yes.
All right. Mr. Miracle, did you discuss your rights and options with counsel today? You understand all those? You understand understand the possible penalty for the charge of overall license suspended, revoked, or denied? And understanding all that, are you in fact pleading guilty to that charge today?
Yes.
On October 2025, did you drive a vehicle in Huron Township?
Yes.
And at that time, was your license suspended, revoked, or denied? Counsel satisfied?
Satisfied, Your Honor.
So am I. I'll dismiss the two charges from August 6th. What's the status of the license now?
I'm both currently, Mr. Miracle is not over to Wayne County, for an official that does impact his license. He understands that this will constitute a violation of probation, that he is on and is prepared to deal with that through my office.
Okay.
As well as he's committed, Your Honor, to when he is first eligible to coming back, and he knows I do these and helping him to get full license restoration. I look forward to that.
Okay. That bottom pan scribble, does it say no payments posted? Okay. Are you working, sir?
Self-employed.
What do you do? What do you do?
Right.
Okay. How long?
2012.
Okay. You working now? Are you working now?
Currently not working. We got work just with the weather.
Yeah. So you're employed. You're just waiting for it to be above zero. Right. Okay. All right.
Well,
Yeah. Tangent alert. So a number of years ago, I met a guy, mutual friend, had a party. So I met this guy. He was a retired carpenter. He's from Michigan, moved to Alaska, was a framer in Alaska, and then moved back, So I'm talking to him. I grew up construction, so I'm talking to him. And I'm like, how long is your building season in Anchorage? He said, what do you mean? I'm like, well, do you just build like from June, July, and August? Or he said, no, we build year round. I'm like, man, I could never get a handle on working with gloves, nail pouches and gloves. And he said, me neither. That's probably why these don't work anymore. Because he worked year round in Anchorage, Alaska. He said, yeah, I got a lot of problems with these. Yeah.
I bet.
Yeah. Yeah. All right. Anything else I should know before I sentence on this file?
Your Honor, like I said, he's a hardworking guy. He knows my office well. He's going to move forward in the right way. So we would ask you to take some consideration of that.
All right. So we've got some old files we owe money on. It looks like $860. Part of that was the case I just kicked out. That was $170. Are you in a position to get some kind of payment set up on a regular basis, weekly, bi-weekly, monthly? Can you get some payment schedule set up on a regular basis?
Yes.
Can you commit to that today? Okay, do that before you get out of my building. All right, so on today's file, fines and costs are $500. I'm ordering 4 days on the court work program. Work program is assessed as an alternative to jail. I would suggest you go down and find out the quickest you can schedule them, because you're either going to work for me during the cold weather or you for the cold weather. So let's get these banged out so when you get a job that actually pays you, you can get it done. Any questions?
And the day off and weekends.
Weekends are tough for us.
Okay.
We're trying to gear up with more weekends, but right now, do the weekdays.
Gotcha.
While you're not working. Yeah, because we're not going to kill you out there. You're not going to work as hard for us out in this weather than you would for you. So with the money you already owe on the old stuff and the 500 day, go down and set up your payment plan.
Will do, Your Honor.
All right, good luck with your license when you get there.
Thank you. Judge,
Always a pleasure.
off the record, our friend John, I'm helping him with something else. He's doing well.
Good.
I brought a Christmas basket for my daughter.
Always. Yeah, he's a sweet guy.
Take care of you.
Say hello to your big boss.
Well,
Caitlin Langley. Miss Langley, are you going forward today without benefit of an attorney? You've met with the prosecutor. Says here that you're going to plead responsible to a double parking civil infraction. You've agreed to pay fines at cost of $150, and the prosecutor wants me to dismiss the misdemeanor. That's all crew? True? All crew? Crew, that's correct and true both. Okay. Can you pay the $150 today? By 3? Okay. Questions? Good to go. Enjoy your day. Devin Rodkey. Like Rodney, but an K instead of an N. Did I pronounce it right?
Yes, sir.
Good morning.
Morning.
You're going forward today without benefit of an attorney?
Yes, sir.
Double parking for you?
Yes, sir.
Fine, the cost $300?
Yes, sir.
And that's the way you want to resolve this today?
Yes, sir.
All right, I'll dismiss both charges from December 19th. Can you pay the 3 today? No.
No.
I'll give you a due date.
Yeah.
Look at the calendar. Tell me how long you need to pay $300. The reason is because all this is on hold until we get your money. Then we put it through to match the deal.
Yes, sir.
You looking for a due date? You can walk over there if your eyes aren't any good. Yeah. So
February 6th work.
February 6th, what day is that? Yep, I like Friday due dates. All right, any questions? Good to go. Stay warm. Meredith Allen. Good morning, ma'am. Are you going forward today without benefit of an attorney?
Yes.
And you've met with the prosecutor? You've agreed to plead responsible to a third charge, double parking. You've agreed to pay fines at cost of $500? Wonderful. I will dismiss the original charges from November 23rd. Can you pay the 5 today? Go down. You're probably going to be the first in line, so you'll get a big smile from the cashier. Have a great day. You're welcome. Yep.
That's on B
Yep.
at 500.
Yep. Good morning, Mr. Young.
Where's your honor?
Studio.
Dean, is it Crumpton? Come on up, sir. Mr. Crumpton, are you going forward today without benefit of an attorney? Let's see what you did. You made a deal with the prosecutor? Oh, all right, you're requesting an adjournment. Okay. March,
I think you want to talk about.
yeah, March 12, 8 a.m.
Yes, whatever I have on. Yep.
You can get started. All right, Mr. Crumpton, we've got 2 files. You've got bond money on both. You've got a civil infraction, which is a speeding ticket. That bond is $300. You've got a misdemeanor, drove while license suspended, revoked, or denied. That bond is $500. If we switch your bonds, that'll give us enough money to pay off the civil infraction. You're done with it. Is that all right with you? Okay. Actually, probably the way to do it is just, yeah, and then whatever's left, put it on.
Put a
Yeah.
big bond on the other one.
All right. So have a seat. We're going to get you a paper notice for that new date. Questions? You're good to go.
So Lily says in the chat, lots of double parkers here. So double parking is this court's equivalent of allowing another to operate a motor vehicle, which is something that Judge Middleton and some other courts use. It's basically a legal loophole to be able to take the charge and plea it down to something that's basically just a fine. So that's what's going on.
All right, you're going to plead responsible to double parking. Prosecutor wants me to dismiss both charges from January 2nd, and you've agreed to pay $300, right? Can you do it today?
No.
Are you working? Where do you work? Mako? Mako? What do they do? All right, where are they at? Okay, how long you been there? Full time? Good. All right, so you owe some money on some other stuff too. Violation of permit, equipment violation. Oh, that's what these are. Yeah. You got to fail to display valid license 2 times. You got one from 23, one from 24. Almost $1,000. So are you in a... Great, but you still owe the money. Yeah. So are you in a position to commit to some payments? Weekly, bi-weekly, monthly, what works? All right. How much can you do and when can you start? No. 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 You're working full time.
Roughly still, but with me, I have to pay with that. That's a lot. Like 3,000, pay back, I can start paying these
Can you do 50 a month? Starting soon?
by February.
Pick a date. 10th? Yeah, we'll always take extra money. But if this way, at least we got you nibbling away at it. All right, so you need to go downstairs and get that on paper before you get out of here. So you go to the front counter, tell them you're setting up a payment plan. Yep. Yep. All right, so that 300 plus what you already owe us, that's one big payment plan. All right, good luck. Good luck.
Barbara, thank you for the 5. Ellie, thanks you. It's very nice of you.
William Burrell. Burrell or Burrell? Mr. Burrell, you're going forward without an attorney, yes? You've made an agreement with the prosecutor, correct? You're going to pay $300 on the double parking and the other 2 get dismissed, right? All right, that's 2 charges from 12/12/25. Can you pay the 3 today? When? Due date over there if you can see the calendar. If you can't, take a walk. 10? 30 days? Yeah, we can do that. Any questions? All right. You can remember that? You don't need a piece of paper from us? All right. Did you hear what I said? If the money doesn't get paid when it was supposed to, then these are back up and you got to deal with them. Gotcha. Yeah, you should be. It's a good deal. Have a good day. You're welcome.
Yes, this is drive, they were driving. It's not working.
Yes, Hardaway. Miss Hardaway, are you going forward today without benefit of an attorney? Okay, so you're pleading responsible to impeding traffic and the misdemeanor charge from 12/31 is dismissed. That's the deal? Okay, impeding traffic is $180. Can you take care of that today? Go downstairs and get your smile and get on your way. You're welcome. Enjoy your day. Morning, Counsel. Is it Hamadi? Come on up. Sir, are you going forward today without an attorney?
Yes, sir.
All right, so you made a deal to plead responsible to double parking and receive 2 dismissals from January 1, correct? And you've agreed to pay fines a cost of $300. Can you pay that today? Go downstairs and get a smile. We'll get you on your way as soon as we can. You're welcome. Enjoy your day. I'm out of files.
All right. Well, if he's out of files, let's move on. Let's go down to Georgia, just like the devil did, and see what's going on with Judge Lull.
First appearance has been had for most of these cases. Individuals have bonds set in their cases as well. And today we're going to find out how each defendant would like to move forward with his or her case. I'm just trying to make sure that everybody is okay, good. So today, after each defendant has had the opportunity to speak with their respective attorney, we will determine whether the defendant would like to accept a plea offer from the state and in exchange for a recommended sentence, or whether the defendant would like to enter a plea of not guilty and the case will be further noticed for trial. Other matters that we may address today include bond modifications, bench warrants, as well as probation. If you are an individual accused of one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything that you choose to say during this virtual proceeding, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. All right, and courtroom 2, we have Mr. Haddad there. Oh, I have Mr. Haddad's checklist over here. Okay, excellent. And Mr. Haddad is there. Mr. White is also on Zoom, and it's just and who else is?
Good morning, Your Honor.
Here today?
Mr. Martell's judge. He's handling the ACDC folks.
Okay.
Morning, Judge.
Good morning, sir. Good morning. Okay. All right. Who do we have first?
Number 31, Mr. Robinson.
Okay, thank you.
Good morning, Your Honor.
Good morning. Good morning. Okay, we have Gennaro Robinson. Mr. Robinson has been accused of battery, family violence, theft by taking, and cruelty in the 3rd degree. Case number is 26 CR 152A. Mr. Robinson, you've been advised of your rights, and your attorney is Mr. Fortis. Mr. Fortis, how are we proceeding today?
Judge, we're going to maintain our not guilty plea at this time, Your Honor.
Okay, and have you filed a waiver of arraignment, or would you like me to arraign this case? I can't recall. Sorry.
We've already filed it, but
Okay.
if you want to arraign it, you can. I can arraign it. Not a problem, but we did file it.
Just the dasher here.
Let me just take a quick look. Miss Young, can you see if this case has got a waiver of arraignment filed? I'm having trouble trying to get.
Not yet, Your Honor. Unless
Okay.
you filed it this morning, it's the other case that has a waiver in it.
All right. Mr. Fortis, do you waive reading of the accusations?
Yes, Judge, we'll waive reading of the accusation, enter a plea of not guilty,
Okay.
and request 10 days from receipt of all discovery to file motions.
All right. Mr. Robinson, your attorney has waived a reading of the accusation. As I've already indicated, the charges that have been brought against you. These are misdemeanor offenses, and you have the right to enter a plea of not guilty, and the case will be scheduled for trial. At the time of the trial, you and your attorney will appear, where the prosecutor would have the complete burden to try and prove the charges against you beyond a reasonable doubt. If the prosecution does prevail and overcomes your legal presumption of innocence, it's a possibility you could be convicted of one or more of these offenses and face a penalty of up to a year in jail and or up to $1,000 fine for each convicted offense. Given this information, how do you plead today?
Judge, we're going to maintain our not guilty plea.
All right. Do you agree with your attorney, Mr. Robinson?
Yes.
All right. Case has been arraigned and further notice for jail jury. Thank you, Ms. Fortis.
Thank you, Your Honor. Good to see you.
You too. Thank you. Next case, please.
We go to number 26, Mr. Mohammed.
Yeah. Hey, Tom, yeah,
This is State versus Khalid Malachi Muhammad, accused of 2 counts of PI. We're going to waive sounding on the charges from July 2nd, 2025. His accusation is 26 CR 220J.
Let's actually change it up, friends. Judge Simpson's just getting his day started. Let's go over there.
Georgia A. Senior Assistant Public Defender. We too do not believe that there is a conflict, but if there is any conflict, we would waive it as well.
Thank you. The court also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people of the state of Michigan versus Sandra Law.
Alex Jamalowski, the people.
Stephanie Can on behalf of Ms. Law. I will let him know. Your Honor,
State your name, please.
Sandra Law.
All right, where do we go?
Ms. Law has elected to waive her right to a preliminary exam. Your Honor, my client is outside of counsel's advice, asking to speak to the court, and she's also asking to have her daughter be allowed to speak to the court. I've informed her that her daughter will likely not be able to speak to the court because that is inappropriate, but she wanted me to ask.
All right, well, you can do the waiver. I don't know what you want to address to the court.
Can I read something to you, please? Your Honor, do you want to address the waiver first? How do you want to proceed?
You want to do the order? What is that, Ms. Cannon? No. If you want to do the waiver, we can. That's fine. Ma'am, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
Understand that you'll not have that hearing. You'll proceed to circuit court for further, bless you. You'll proceed to circuit court for further proceedings.
Yes.
All right. People also waive their right?
Yes.
Preliminary examination having been waived, found over to circuit court on count 1 with 2 following.
Your Honor, we would waive formal reading of the information, stand mute, and we're asking for our next pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 2nd at 1:30 before judgment.
February 2nd, 2026, 1:30. Judge will move.
Can I read something to you, Your Honor?
As long as it's not too long, go ahead.
It's not. I apologize to you and your court for my situation of my stinking thinking attitude to allow my relapse and my time of sorrow. I've been caught in addiction for 15 years. Before this relapse, I have been sober for over a year. As of now, I have been incarcerated for 78 days, waiting for a plea deal to be sent to treatment. So far, there has been no eval. I was set to leave for treatment on a tether to Oakdale twice and subsequently been let down both times. There was a delay in my relapse due to bond differences in between both cases. I was not present for my Medicare renewal, so it has canceled. I'm concerned about me not being eligible to pay or have insurance pay for my long-term treatment. I worked hard in my sobriety to have a productive life. I went from having nothing in my life but a pipe and a rock to having things that make my life of importance: a job, schooling, a home, surrounded by my family, pets. I accumulated all that back. I write this to your court today to ask that I be released today to go back to my productive lifestyle that I struggled for. I have an awesome support system, a sponsor. I will continue outpatient treatment, drug testing, and my sobriety. I want a chance to show to this court I can be a responsible, clean, and sober out of jail. Thank you for your time.
Yes, I'm gonna be real. I've listened to this now 3-4 times. My position has not changed, and it is not going to change regarding this case. I did approve. The last one I approved was January 14th, her release to treatment.
Understood, Your Honor.
And that is what I said I would do every time. I approved it. I don't know what has happened there. Somebody else can look at that. But I'm not changing my position, Ms. Law. You can keep saying the same thing over and over. I'm not going to do anything different.
I understand that, but what has held me back is with the treatment situation. Okay, I was put on a 90-day home arrest tether with Miss Washington's case. And me going to Oakdale, they set me back, they put me on a tether, and I couldn't leave. So my case with her is up, and I did my time in jail with her. It'd be Monday. So that's what set me back from treatment. And I have an eviction on my home that you did. I have to be out April 1st. So it's like I'm facing an eviction that I can't get
I've
my
heard all
possessions
of
out.
this, Ms. Law.
I
I
understand.
know this. It's not like I'm operating in the dark. I have heard everything that you are telling me now 2, 3, 4 times.
I understand that, and I don't understand why I don't deserve a chance to go do outpatient treatment and get my life back on track over one relapse. I mean,
Did you hear me?
Yes.
I approved outpatient treatment for you.
You didn't improve outpatient, you improved inpatient.
You want to see the form? I
Thank you.
signed it January 14th. I'm done. Bond continued. Bye.
Thank you, Your Honor.
Goodbye.
I don't understand.
That was one case. One case.
Great start, Your Honor.
No, and you were involved, Cam. Thank you. Court calls the case, People versus Avion Johnson.
Morning, Your Honor. Chief Assistant Prosecutor Victoria Burton here is appearing on behalf of the people.
You were not supposed to let all that happen to me. Never mind.
Your Honor, I'm so sorry.
Good morning.
Good morning, Your Honor. Edward Drugas on behalf of Avion Johnson.
And Mr. Johnson, can you unmute and state your name, please, sir?
Good afternoon. Well, good morning. Avion Johnson.
Good morning, sir. All right, what are we doing?
Your Honor, I'm asking for an adjournment. We were downloading videos and we need some more time.
More time.
So
what am I doing? The 5th, I gotta skip that one. 5th and 12th. How long are you intending on being in Oakland? How long are you gonna be in Oakland County Jail? Do you know?
To May.
he's till May.
Till May, all right. Probable cause conference will be adjourned to February 12th. 2026, 9/8. Bond continued.
Thank you.
Yeah. Court calls the case of the People versus James Kimbrough.
Chief Assistant Prosecutor Victoria Burton here is appearing on behalf of the people.
Edward Drugas on behalf of James Kimbrough.
James Kimbrough. All right.
Your Honor, we're just needing a brief adjournment. This case is going to be nallied.
And I'll adjourn this to the 5th. February 5th, 2026, 9/8. Bond continued.
Thank you, Your Honor.
Calls case People versus Marcus Claybrown.
Morning, Your Honor. Morning, Your Honor. Sam Bernstein for Marcus Claybrown. Mr. Claybrown, can you please state your name for the court?
Marcus Claybrown. Thank you.
Your Honor, we're asking for an adjournment to obtain a review discovery.
All right. Is he being held on anything else other than this?
Just this, I believe, Your Honor.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus David Gilbert.
Carolyn Foster Tucker on behalf of David Gilbert. He is on Zoom? No. Is he on Zoom? No, he's not on Zoom. I have no explanation for his absence. For the record, I'd ask for an adjournment.
Then what were you looking at the door? Never mind. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor.
Court calls case People versus Joseph Bonville.
Your Honor.
Brandon Bird on behalf of Joseph Fonville. Mr. Fonville, can you please state your full name for the record? Joseph Fonville.
Thank you. All right, you're requesting an adjournment.
I'm correct, Your Honor.
All right, is this the only thing he's held on?
I believe, is this the only thing?
Yeah.
I believe so.
Yeah.
All right.
Probable cause conference then will be February 5th, 2026, 9 a.m. Bond continued.
Just permission to address bond, Your Honor.
Go ahead.
Respectfully, my client indicated to us that he does have Medicaid and he's looking to be released to community health. It's not the fact that
to community health,
mental health.
Yeah.
He's looking for some sort of mental health treatment. It's not the fact that he can't afford bond. He could have been posted bond if he wanted to, but actually, and he has a place to stay. So it's not like he's using the jail as housing either. But he's been trying to make sure he stays out of trouble. But he really wants to address some mental issues, and he's just asking this court, can he please be released to mental health?
I'm not going to have an issue with that necessarily. I mean, he's got $1,000, 10% bond, I think it is on this case. So, I mean, it's not like we're really holding him. If you prepare an order, I'm sure the jail will use their resources to try to see something that will see if there's something available for him.
Thank you, Jan.
All right, thank you. So at this point, his bond will continue.
Thank you. Any honorable court, have a great day.
You did, are you done?
Done.
I should make you stay.
As long as you buying lunch.
Court calls the case, People versus Marissa Dix.
Good morning, Your Honor. Robert Ellman on behalf of Ms. Dix, who should be present over Zoom.
Good morning, Your Honor.
Good morning. State your name, please.
Marissa Dix.
Okay. I have before me a plea form that indicates that the defendant would be pleading to a doesn't say kind of plea. I'm presuming since I read the police report, it's a no contest.
That's correct, Your Honor. My apologies.
No contest plea to count 3 of stalking, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is also agreeing to complete full 5 years probation with no early discharge, not object to any personal protection order extension by the victim, participate in mental health treatment, complete a substance abuse assessment, and follow all recommendations from that assessment. That is what the defendant is agreeing to do. The prosecutor and defendant agree that the prosecutor will recommend that a current PPO violation will be dismissed. That's the court's full understanding of it.
The defense understanding as well.
Dix, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
State your name again for the record.
Marissa Dix.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge or pleading no contest to the charge of stalking. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine, and up to 5 years probation. You understand that, ma'am?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. Two things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Do you still wish to plead no contest?
Yes.
Basis for no contest plea?
Potential civil liability. Your Honor.
All right. To the charge of stalking, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You had executed or caused to be executed in advice of rights form?
I'm sorry, what was
Your
that?
Honor.
You caused to be executed in advice of rights form, meaning you went through it with your attorney and your attorney signed with permission, or you signed off on an advice of rights form?
Yes, I did.
All right. Do you have any question regarding any of those rights?
No, I do not.
All right. With particular attention to paragraph 5, which are your trial rights, you understand that you're waiving or giving up all of those rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not currently. Not yet.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
All right. Court has been provided and has reviewed 2 police reports. Both Ann Arbor Police Department reports for their case numbers 25-51811 and also for 25-40451. Any objections to the court having reviewed those reports?
No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ms. Dix, I do have to inform you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
People are not, Your Honor.
No, Your Honor.
And have I complied with the court?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
February 18th at 9 a.m. before Judge Perry.
said 18th.
Yes.
February 18th, 2026, 8:30 before Judge Perry. 9 a.m. before Judge Perry, excuse me.
Thank you.
Bond will continue. Thank you. Thank you, Ms. Dix.
Thank you, Your Honor.
May
Have a good day.
may I address Bond shortly? She still has a GPS tether on now that the charge has been reduced. Is there any chance of removal of the tether prior to sentencing?
I am not going to remove it.
Fair enough, Your Honor. Thank you.
Okay.
Thank you.
I like that kind of bond motion. Thank you, Mr. Elman. Court does call the case of People versus Seth Cronick.
Morning, Your Honor. You cannot pretty bad people.
Morning, Your Honor. Chris Eastup appearing on behalf and with Seth Cronick.
Your name, sir?
Seth Cronick, Your Honor.
All right.
Your Honor, today, my client understands he has a right to a preliminary exam. He's knowingly going to waive his right and be bound over the circuit.
Is that a correct statement, sir?
Yes, Your Honor.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses pledged were committed and committed?
Yes, Your Honor.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with two following. Mr. Easto.
Your Honor, waive formal reading, stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
February 4th at 1:30 before Judge Conley.
February 4th, 2026, 1:30, Judge Conley. Bond continued. Does call the cases of the people versus Kimberly Douglas. Two cases.
Top 10 last of the people.
This is Mr. Gaddy. Oh, there he is.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Douglas, who is here via Zoom, Judge.
All right, Ms. Douglas, can you state your name for me?
Kimberly Sue Douglas.
Your Honor, I'm requesting a brief adjournment of this matter. The people have made an offer. It was after I visited Ms. Douglas yesterday, and she's not able to appear here today, so I couldn't see her in lockup about it.
Yeah. Is this the only case holding her? Yes.
I do not believe so, Judge.
All right, gotcha. All right, probable cause then will be adjourned February 5th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue.
I'll come visit you, Ms. Douglas.
Thank you.
Does call the cases of the people versus Giovanni Moot.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Moot, Your Honor, on cases not ending in 1665.
Gotcha.
Good morning, Your Honor. James Belsky appearing on behalf of Mr. Moot on the case 1665.
All right.
And Your Honor,
Your name, sir?
Giovanni Moot.
Thank you.
Your Honor, we are just seeking an adjournment. We have an ongoing investigation that should hopefully be wrapped up in the next couple of weeks.
I'm also waiting on some electronic video discovery, Your Honor.
And we have, I have confirmation that that was sent via mail yesterday, so he should be receiving that soon.
All right. So 5th or the 12th, which would you prefer?
I'd prefer the 12th. I have a conflict on the 5th.
I would defer to Mr. Pipelski.
Probable cause conference, February 12th, 2026.
That'll give us more time.
9 a.m. Bond continued.
Thank you, Your Honor.
Once again, good morning, everybody. Welcome to TCF Live. Good to have you here. Lots going on today. I've got my eyes on something that, if it comes to fruition, we'll discuss later. A bunch of different courts are starting to come online. We have sidebar tonight, where the jumping off point is going to be that Louisiana Parole Board case we saw at the end of the 4th hour yesterday. And right after this show, so what is that, 1 p.m. Eastern, 10 a.m. Pacific is what that would be. The premiere episode of In the Blind with Mike and Dan. Yes, Michael Groff, guest host of this show, and I have teamed up for a brand new show. And all you have to do is stick around here, and YouTube will send you right over to that premiere just as soon as this is done. I can continue to ride with Judge Simpson for a little bit. I've got my eyes on him because former U of M coach Sharon Moore is supposed to be in his court today, so we'll keep an eye.
On behalf of Ms. Thomas in the matters ending in 5653 and 1211.
All right. You got it. You got to give him the space. Your name, ma'am?
Hello, I'm Kiwana Quay, Cynthia Rose Thomas.
And Your Honor, we're asking for adjournment. We are attempting to seek a global resolution for the matters that she has outstanding. And our office has been in contact with the prosecutor regarding that, so hopefully we'll have some sort of resolution soon.
All right.
That's not a problem.
How much time are you going to need to try to wrap all of these up?
It's a lot of information for the prosecutor to.
Are you saying they're slow? You're saying they're slow and can't pick up the information? What are you saying?
No, it's a lot to,
Oh,
go
okay.
over and come to a resolution.
I didn't know what you were
But we
saying.
have the big dogs now, Your Honor, so
Wow.
you're not. Things gonna happen.
My staff make things happen every single day.
Her staff is phenomenal.
Okay, now that we've gotten done with the pat on the backs, how much time do we need? Pardon?
And at which point I do believe my client will be in treatment by then, so.
Okay. Probable cause conference, February 19th, 2026, 9 a.m. Bond continued. Talk. Court calls case of People versus Cynthia, is it Dupless? Okay. I'm forgetting an S in there somewhere. Come on up, ma'am. We don't, this is a public defender case, but I don't know who's assigned.
Rob Down, Assistant Prosecuting Attorney, on behalf of the.
Bruce here.
Yeah, the substitution is being emailed to me.
Substitution. Okay.
Oh, the subs,
The substitution, matter is being emailed.
right now.
Yeah.
Okay, go ahead.
Good morning, Your Honor. Jordan Goldberg, P 87047. I'm standing in for newly substituted counsel Nicholas Somberg on behalf of Ms. Duplessis.
You have no objection to that, ma'am?
No.
All right. What are we doing?
Your Honor, we would ask that you set it for an exam. I have Mr. Somberg's calendar.
Is all discovery complete?
He has received discovery. He is still reviewing it, but he is ready to go for an exam.
I understand what you're saying to me. My question is all discovery complete?
I believe so, Your Honor.
People have their witnesses available the third.
Your Honor, I'm actually in trial that week with Judge Moody.
Any objection to going beyond that date, counsel?
No, Your Honor. We would waive 21 days.
The 10th? Will that work for the people?
Yes, sir.
Yes, Your Honor.
Preliminary examination in person, February 10th, 2026, 9 a.m. That's before Judge Freshout.
And I do have one bond issue I'd like to address.
Go ahead.
Your Honor, my client has no felony criminal history. I understand the charges in this case are serious. She has been ordered not to have contact, obviously, with either complaining witness, but she's also ordered not to have contact with children of any kind. She's been ordered not to return to her own house, where one of the complaining witnesses previously resided and no longer resides. As a result, she's been living out of her car. She's been driving 2 hours from Clinton to Adrian to work every day. Your Honor, I'd be asked that you modify bond to permit her to have supervised time with her 3 children separate from the complaining witness in this case, and also return to her home in Clinton. Her husband, who is the father of her 3 children, separate and completely unrelated to this case, is present. He would be present for any supervised time with the children, who again are not complaining witnesses in this case. I believe the bond condition that she not have contact with any of her children at all is overbroad and unreasonable.
Your Honor, I was at the arraignment. It was supervised visit to be supervised by Lenawee County CPS.
That's already been ordered.
Yeah.
That's what I see.
Then the only outstanding matter would be permitting her to return to her home. It was previously listed as the home of one of the complaining witnesses. None of them stay there anymore. The people who live there are her 3 children and her husband, her 3 children who are not related.
Who is Khalil Harvey?
I believe that is
That is one of the.
I know, but who is that to this defendant?
An ex and a child of her father. He is one of the complaining witnesses.
She indicated in the arraignment that she was living on Carriage Avenue in Canton, Michigan. Is that not true?
That's where I had to stay.
I believe that's where she was sleeping during the arraignment, but that has since changed.
I don't think the victim or The child is in Clinton, so I don't have an objection.
They what?
They're not in Clinton. The address in Clinton. They're with the father, the other two children who are not involved in the case.
I don't have, that's not the prohibited address I have in Clinton.
How about this?
I have a prohibited address of Ann Arbor, on Ann Arbor Trail. And then Post Oak Drive, okay, that one I see. Post Oak Drive, they didn't list the town. So those are the two that I have.
Right. If we could do a stipulation if you want.
I think you need to, because I don't know what
We're asking she be allowed to return to Post Oak Drive.
I understand what you said, but you're not giving me all of the information regarding who's there, who's not there.
Yeah, I can put it in the written motion if that's preferable.
Why don't you try this? Call Mr. Talk to him and then see if you can stipulate. If you can't stipulate, then I'll be happy to hear your motion.
Happy to do that, Your Honor. Thank you so much.
Bond is continued. Motion at this point is denied. Thank you, ma'am. Court calls the case, People versus Devontae Connor Belcher.
Sherilyn Foster Tucker on behalf of Devontae Connor Belcher.
Your name, sir?
Devontae Connor Belcher.
Thank you. What are we doing?
Judge, there should be an amended complaint.
Yes.
I emailed that to Mr. Bernstein. I informed Ms. Foster Tucker about it. It's just a comment.
And then it's gonna be remanded on count 2 down.
Yes.
Yes.
So without objection, count 1 is dismissed. As to count 2, you waive reading of that and stand mute.
Yes, Your Honor.
And he pleads not guilty to that charge.
That is correct.
Pleads not guilty to count 2. Retrial in that matter,
8:30 before Judge Perry.
February 11, 2026, 8:30, right? Before Judge Perry. Bond with its conditions.
Thank you.
Thank you.
Have a good day, Your Honor.
You do the same. Court calls the case, People versus Jala. Is it Jala Allen?
When you're reading to the people.
Assistant Public Defender with and on behalf of Ms. Allen. Would you please? Jayla Allen. Okay.
I was gonna try that first and I said, nah. Anyway, go ahead.
Your Honor, we have requested some additional media discovery and are requesting of an adjournment.
Okay, that's fine. Do I have a green sheet? Or
Yes, Your Honor. Well, excuse me.
it's being done?
It is completed. It is right there.
Oh, so it was late? Yes.
Yes.
Don't worry about it. Okay, it's Miss Gaines. We'll let it slide.
I apologize. I don't know why I was sitting there holding them. I said that to her.
No, it's okay. February 12th, will that work? Or you want the name? Or you gonna need more time?
Okay.
12th to work. February 12th, 2026, 9 a.m. Bond continued. Thank you. Court calls the case, People versus Mary Barney.
Morning, Judge Michael Ganny, Assistant Public Defender on behalf of Ms. Barney, who's here in the courtroom. If you could state your name, Miss Barney.
Mary Barney.
Yeah, what do we do?
Your Honor, this is going to be a waiver. I have gone over, Ms. Barney is executing the waiver forms as we speak. The people have agreed not to add any additional charges, Judge.
So she's waiving on both cases.
She is waiving on both cases, Judge.
Ma'am, is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and you committed them.
Yes, I understand.
You understand that you will not have that hearing? And
Yes.
you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on the case ending in 2206 on all 4 counts. And on the other matter, 1869, counts 1, 2, 3 with 4 following.
That is correct, Your Honor. I have gone over her right to an exam with Ms. Barney, as has the court.
Okay.
In terms of arraignment on the information, we'd waive reading, stand mute.
Defendant every way formal reading standing mute. Court will enter a not guilty plea as to all 8 counts. Pretrial in these matters will be set for February 3rd, 2026, 1:30 before Judge Cohen.
Thank you, Judge.
Thank you. Yes, ma'am, surely. Well, I can get it. Sorry, get her the information done. Court does call the case People versus Amber Lee Almany.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Almany, Your Honor.
I have before me a plea form that indicates that she is going to be pleading guilty to the charge of firearms charge of possession on restricted premises, the 90-day offense. On her successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement. The prosecutor's delayed sentence under 771.1 to dismiss the case upon successful completion of delayed sentence term set by the court. That's the court's full understanding.
That's the extent of our agreement, Judge.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth. So be it.
Yes.
State your name, please.
Amber Almany.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of possession of a firearm in unrestricted premises.
Yes.
Now, that is a misdemeanor, punishable by up to 90 days incarceration or $100 fine plus court costs. I think it also requires forfeiture of the device and mandatory forfeiture of the device or weapon. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo or her successor, likely. I don't know who's going to be handling the dockets, but Judge Garwood in the 15th District Court. You understand that?
Yes.
Okay. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form.
I did.
Any question about those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty. June 28, 2025. Location of 1514 East Hospital Drive, City of Ann Arbor, Washtenaw County, State of Michigan. And I believe that's part of U of M hospital premises. Did you have a weapon in your possession?
I did.
All right. And you were carrying that weapon?
It was in the vehicle. Yeah.
It was in your vehicle? And you understand that you were not, that the hospital location is prohibited premises?
Yes.
To do that. You understand that? All right. Ma'am, if I accept your plea, if you, between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, first of all, would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Judge.
And have I complied with the court?
Yes.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at the district court probation. Sentencing in this matter will be
February 17th at 9 a.m.
February 17th. Mr. Feaster, can you approach on a separate matter, please? February 17th, 2026. What time? For Judge Rattleboro.
All right, I'll keep an eye on Judge Simpson's court, but let's move along, go down to Texas, say good morning to Judge Stevens.
Said about me. That's strange. That's what the doctor said I needed.
What?
I knew that. She said I needed it.
3 minutes too slow.
Oh, yeah, that was 3 minutes behind.
Yeah.
That's a pretty good joke. At least you're not funny. Okay, you were, Mr. Cruz, in 25 CR 804, Alejandro, you were charged with the state jail felony of burglary of a building. If convicted, that carries with it up to 2 years in the state jail, which is not a good thing. What are we going to do today?
There's just an initial, I still have the medium on him if I have a couple weeks to get that.
It's July. He was indicted in July.
This is my first appearance.
I don't know, but it shouldn't take. Have you moved recently?
I was in custody in LA. I was in custody
Where?
in Brazoria County.
To when?
About October.
For what? For a charge over there? What was it?
The same charge.
So what happened in the case? Did it get,
yes,
it get disposed of?
yes.
Okay. You know that?
I wasn't aware of that.
So
This is my first appearance, which is
I'm talking about over there, because I don't see a criminal history here, but you were convicted in that other one?
yes.
What was it? What was?
State jail, 1244. They gave me
Oh,
1244.
1244. Okay,
Yes.
but it's still a state jail
Yes,
conviction,
yes,
but you received punishment as though it was a misdemeanor.
yes.
Those are good things if you can get them. And what was the crime?
Same-
Burglary of a building?
same-
Was it this? It wasn't the same event.
No, it was
It was a different
two
event.
different
Okay.
locations.
Okay. Miss Time, you gotta get a resetting this time.
Yes.
Here, sir.
Chester Fobbs, please. FOBBS.
Oh, sorry, here. Yeah.
I didn't want to read.
Camera left up, man.
Thoughts? Are you Chester Fobbs? I'm calling cause number 25, CR 1663. And you are charged here by an indictment with failure to comply with sex offender registration, which you were required for life, right? This, you have to do that for life. And this is a third degree felony. That's why you have to be very cautious and ensure that you register regularly and timely. Because if convicted of this, you are facing up to 10 years in prison. That's the way it is. It's a third degree felony for not registering properly. What are we going to do today?
Judge, I need some time to go over the media with.
They just got indicted
It's new.
a couple of months ago, so I'll give you 4 weeks on this. Are you registered properly now?
Yes.
I mean, there was a hesitation. You're nodding vigorously.
Yes. This morning.
I know, but we gotta verify.
Yes.
Just state no, the answer to that.
I don't know off the top of my head. I can look into
You
it.
look, I don't want him leaving until I find out if he's registered properly right now. Okay? No, it's a crime.
No, I
And
understand,
it's
Judge.
going to affect his bond if he's not. But he's got a duty to do it, and he's got to do it. And I don't want you to leave until I know whether you have been properly registered and complying with this registration. Because every day it's a crime.
Yeah, change of address.
Is that what you did?
Yes. It came to me.
Okay, let's just verify it before Mr. Fobbs leaves. Okay, don't leave, make sure it's, we'll put this on the side. Here, I'll need this on the side. Remind me, Mr. Fobbs. I mean, that's,
The reset.
legislature makes that very important. And when you get caught not registered, the first thing you have to do is register.
Yes, sir.
If you're not in jail already.
I'm sorry, I need you to sign right there on the high level. That's for me.
Just. Judge, you want me to sit over here? While they do it?
Yeah, I can see that. Thank you. Ricardo Kelly. Ricardo Kelly, come forward, please. Twenty-three CR 2261 is called. You are Ricardo Kelly?
Yes, sir.
Wow. You were, this is your first appearance in this case, right?
Yes, sir.
You were indicted over 2 years ago. You must have moved around.
Yes.
You're still at 11514?
No.
So what's your address?
947 West 13th Street. Hold on, Texas.
Hold on, Tex. You're shooting fast, Tim. Seven,
640.
I have 947 West 13th.
Yes, sir.
Okay. You're no longer at 11514.
No, sir.
That was it. That was the problem.
Yeah, no, so like 8 things.
Okay, once again, this carries with it if convicted up to 2 years in the state jail. I don't see any prior convictions on this. Are you getting a lawyer?
I was supposed to be assigned a court appointed lawyer.
I'm sorry?
I was assigned a court appointed lawyer.
Why?
So I asked.
I've been working since the day I turned 16. I paid my own way. Everybody else, if I can do it, anybody can do it. The people, the taxpayers are not going to pay your way. Are you able to work?
No.
Okay, I expect you to work and pay for your lawyer. That's what we all have to do. You're not going to rewrite the system. You've got to go and get a job and pay for your lawyer. Now, we're going to get you somebody appointed, but you're going to pay for the people of this county to represent you. They're the ones carrying the burden, but you're the one charged with the crime. They shouldn't be. Is that too hard to figure out? It's really not. You made a mistake, according to the grand jury. Just like everybody makes mistakes, you got to fix it. And it's your responsibility, just like it's mine. And I have to put gas in the car. The person parked next to me doesn't pay for it. We've got to take care of our own obligations. And this is an obligation. I expect you, if you're able to work, to go out, get a job, and pay the people back who are going to be footing the bill for your representation. You understand? It's just the way it works every day. Not a free ride system. Somebody's paying for everything. And it's the taxpayers, included, which you are included in that. That's why you got to do your part like we all do. When was the last time you were employed?
I'm employed.
Oh, good. What are you doing?
I'm a ship manager.
Okay. Have you ever worked with them before?
Yeah.
That company before? They have a pretty good deal going. And you're a manager? Well, you've got responsibility. Okay. What do you make an hour over there?
12.
I'm sorry?
$12 an hour.
$12? Okay, that's 25. That's 25 annual. One thing you need to do, he needs to fill out one of these, incomes, financial forms. That's not in here. And that has to always be in here when, somebody is, not represented, is not represented by a retained lawyer. So you're gonna have to fill that out. I'll look at it, and we're gonna get you some help until you can hire somebody. We're going to get you some help to represent you, one of the public defenders here. Okay. And we'll introduce you to them. Fill that out first, though. Okay. Right over there in the box. Okay. We're going to just reset this for a review in about 4 weeks.
Yes, sir.
Okay.
All right, friends, what do you say we try something new, something different? So we're going to go to Dickinson County, Michigan. This is the Iron Mountain area, so like the very west side of the Upper Peninsula. This is Judge Julie Lacoste. Let's see what she's all about.
Carlson, prosecuting attorney's office, is not here this morning of their own choosing. We're set for a sentencing. We did get the assessment, excuse me, to that extent, it's updated, recommending an alcohol highway safety program. Do you have that update?
I didn't see it, Judge, but I was informed of the same from the probation department.
All right, I have reviewed the assessment. It was done by Vanessa Larson. In respect to the matter, then, is there anything factually inaccurate in the report?
No, Your Honor.
Anything that you need to update or correct?
No, Your Honor.
Have you been over it with Ms. Kitzman?
I have, Judge.
All right. Anything you'd like to tell the court before the court imposes a sentence on behalf of Ms. Kitzman?
Judge, if I may just briefly.
You may.
Your Honor, thank you. Your Honor, Ms. Kitzman appears before this honorable court. As the court can see, for a first time interaction with law enforcement and a first criminal conviction. Your Honor, I referenced it to Ms. Kitzman, and I've heard you say it, if I had a dollar for every time you said it, and probably I said it as well. Good people make bad decisions. Ms. Kitzman was out this night and celebrating, and things got away from her, very obviously. Your Honor, she consumed much more than she intended. She consumed much more than she should have to drive. Your Honor, frankly, things got away from her. But the other thing, Judge, and I was chatting with her about this as well, when we see high BACs, it causes us pause, causes us some concern. And I've discussed with her that concern because of the high level. You know, even though perhaps that night she made a bad decision, there was a history that led up to it to be able to get to that level. And the way I've explained it and chatted with her, we've had discussions about it. Sometimes these things happen, and it allows us to take an inventory of kind of where we're at in our lives and how we got there. And I've portrayed this and talked with Ms. Kitzman. We've discussed it and taken this as an opportunity to do an evaluation and take a step back. She's going to have to do that because her license is going to have these restrictions with the high BAC, as the court knows and she knows. She's going to have a suspension followed by a full year of having that interlock in her car. So she'll have a daily reminder every time she starts that vehicle of her actions that evening and how things got away from her. And because things got away from her, she has ramifications, Judge. Thankfully, nobody got hurt, her included, her fiance as well. There was a parked car. Nobody was in it, but it was damaged, and it could have been much worse. And that was the first thing that she made the comment to me when she called me was, thank goodness nobody got hurt. I can't believe I'm in this situation. I don't know how I got here. This was Your Honor, so all that being said, I think that the lack of criminal history, she is not a 21-year-old young lady making youthful, foolish decisions. She knows better, and this is just simply an opportunity for her to make amends with herself, the community, this court, her family, and make better decisions in the future, because next time there will be bigger ramifications, including mandatory jail, license sanctions, but also if somebody gets hurt, the fallout could be much, much more dramatic. So, Your Honor, based upon the lack of criminal history, based upon the isolated circumstances,
And I think also important, I watched the entire video, of course. She was very cooperative with the officers, very respectful, very courteous with them. She acknowledged, as noted in the incident report, that she drank too much alcohol, that she shouldn't be driving. So I think she immediately realized her bad decision-making that evening. Your Honor, I think the recommendations are appropriate. I think they're in line with what we normally see with a situation like this on a first offense. We'd ask the court to follow the recommendations. I anticipate that the court would adopt the sober link based on the level of the VAC. I would note, as the court notes, she will have the interlock in her vehicle separate from this. But if the court perhaps considers that a bit, I don't know if the suspension has started already, but she will have a sober link in her vehicle as well. So I'd ask the court to take that into consideration when handing down its ultimate sentence. Thank you, Judge.
Yes. Ms. Kitzman, anything you'd like to add before the court imposes a sentence?
No, Your Honor.
All right. All right, then concerning the matter, Ms. Kitzman, I think your attorney has hit the nail on the head in respect to the matter. You're extraordinarily lucky that nobody was injured. Your fiance wasn't injured. Nobody was in the vehicle that you hit. But as I read the police report, you were quite well inebriated and really should not have been behind the wheel of the vehicle. So you have to make smarter choices from here on out, especially working in the field that you do. You're going to have to abstain, not just while you're on probation, but you've got to make sure that you don't make this mistake again, because 1 is tough, right? 2 is almost insurmountable at times, especially if you value driving privileges. So in respect to the matter, then make sure that you abide by the terms of your sober link. You know, just the fact that in an environment like this, you're no longer able to use your remote starter because you have to be there to blow into that machine. So it's all, you know, it's all part and parcel of the hole that you've dug. Now, this is not a hole you can't dig out from. This is something that you pick yourself up, you brush yourself off, and you move forward having learned some lessons in life. What I like to say is that nobody's perfect. We all make mistakes, but it's how we fix our mistakes that define us. So make sure that you just be smarter than this and that you make better choices. All right, I know you can do that. All right, I think the recommendations are appropriate. I'm going to place you on a 9-month term of probation. There's a $300 oversight fee. This is one of those cases that is subject to early discharge from probation. So you can talk to Mr. Carlson about it if you don't understand the advisal. Fines and costs are $640. There's a $75 prosecutor's fee, $100 in restitution payable to Kingsford Public Safety. Crime fund fee is $75. The justice system assessment fee is $50. It's a total of $1,240. The recommendation is for $150 a month, starting March 1st. Can you do that?
I have money with me, Your Honor, to pay it today.
All right. Good for you. I'll order that be paid in full today then. 20 days in jail, 1 day credit, 19 days suspended if you complete 38 days on the sober link. I see them as independent and distinct of one another. In regard to the vehicle, that's going to be something you need to do each time you step in the vehicle. However, the sober link is something you're going to be blowing into approximately 6 times a day for the next 38 days. All right, I'm going to order that you attend the Alcohol Highway Safety Program as recommended. In addition, like I said, to the general terms of your probation, which are listed as 1 through 7 on the top, the following are specific to you. You must absolutely abstain from the possession or consumption of alcoholic liquor in any form whatsoever. You may not use, possess, or consume any non-prescribed controlled substances or prescription medicines that are not prescribed to you. You must avoid all people that use, sell, or possess those items. Do you have a medicinal marijuana card?
I do not.
All right, unless or until further order of the court, do not use or possess either medicinal or recreational marijuana. You're subject to random breath tests and drug screens while you're on probation. Refrain from entering or remaining in places of business where alcohol is sold for use therein, excluding during the course of your employment and during your hours of employment at the T&T Steakhouse. If I didn't say it, random breath tests and drug screens. Do you understand the terms of your probation?
I do, Your Honor.
And did you understand your appeal rights?
I did.
All right, then. Mr. Carlson, anything?
No, Your Honor, thank you.
All right, good luck to you, Ms. Kitzman. Please wait for your paperwork.
Okay, quick interruption here. First off, Michael in the chat says it's a cute little courtroom, like baby's first courtroom. I think it's a good way to put it. I thought it'd be fun to go up there, though. It's, you know, the Iron Mountain area isn't exactly a booming metropolis, so I thought it'd be fun to take a look at and kind of see what was going on up there. It just popped up in my feed yesterday, and I watched a little bit of that court offline, and it's kind of interesting. Now let's address Barbara real quick. So first off, Barbara, thank you for gifting 5 memberships, but you said, I hope this makes up for the pre-show. I want to be clear to every one of you. First off, none of you owe me anything, okay? And we don't apologize here at TCF for anything. For those of you who are in the pre-show, you know what we're talking about. For the rest of you, it doesn't specifically matter the details. But, Barbara, you didn't do anything wrong. In fact, you might have clued us into something that is worthwhile. I've got my eyes on it. Nothing's happening yet. But if it does and it makes sense, we'll take a look at it. I feel bad, though, that there is a YouTube actor out there who's taking advantage of people. And more importantly, he's taking advantage of the name of a good man to boost himself up. And that bothers me. But I'm not bothered by anything with you or any one of you out in the audience. You guys are the greatest. You're the best. And Barbara, you are the most helpful person on this channel, bar none. You're out there posting links and keeping everybody informed, and you're doing all these things. So don't apologize for anything ever. There's no need. Okay? We're good. Trust me. And I appreciate everything you do. I probably don't say it enough, more because I don't know how to express it enough, I guess. But this would not be the place it is without people like you, Barbara. So don't worry about it. We're good. Let's go to a place where maybe people aren't good. Let's go to the parole board.
22nd. The time is 9:06. My name is Carolyn Stapleton. I'll be the chair of the panel today. My colleagues are joining us by Zoom, Mr. Steve Prater and Ms. Jerry Ledoux. Is there any staff where you're at, sir, at Orleans Parish Prison?
Right outside the door.
Pardon?
They got one outside the door.
Okay. They're right outside the door. They can come in and introduce themselves for the record.
Yeah, you want me to call them in?
That's okay. Normally they're inside. Okay. Well, will you introduce yourself and DOC number for the record, please?
My name is Sean Dennis. My DOC number is 729-679.
Okay. And to repeat, our remote location is at Orleans Justice Center. Do you have a questionnaire in front of you, sir?
A questionnaire, no ma'am.
Yeah, they'll put it up on the screen.
What you say, ma'am?
They're gonna put it up on the screen.
Yeah, I have that paper. I'm sorry. Yeah, I have that paper.
Okay, well, based upon your answers to this questionnaire, you are not eligible today for appointed counsel. All right. You have people here today in support of you. A Miss Miguel, and then a Miss Judy Palmer, which is your mother. The person taking lead for your case today is Miss Jerry Ledoux. She will answer your she will ask you the questions on your revocation sheet. You will answer guilty or not guilty, with or without a statement. Ms. Ledoux, did you want him to start off with his support first?
No, ma'am, I'd like to get the pleading out of the way. Mr. Dennis, I'm going to read the allegations against you and then give me a plea of guilty, guilty with a statement, or not guilty. Condition number 4 says you failed to refrain from criminal activity. You were arrested 8/29/25 by NOPD and booked with domestic abuse battery, with child endangerment, that there were marks on the victim's body. And on 10/28/25, the charges were refused because the victim recanted. So what is your plea to that?
Not guilty.
Number 6, you failed to work at a job that was approved and you could not provide evidence of employment. What is your plea?
Not guilty.
Number 10, you are currently behind $758 paying your fees for the Department of Correction. How do you plead?
Not guilty.
Okay. So, you had a job?
Yes, ma'am.
And your parole officer knew you had this job?
Yes, ma'am.
Was it a job that you got a paycheck for?
Yes, ma'am.
So why would he say you didn't have a job?
I don't have no idea, ma'am. I was working at the Blue Crab on the lakeshore front. Lakeshore Drive. I was working at the Blue Crab. He knew I had a job.
Okay, and you're not behind in your fees?
Yes, I'm behind on my fees, man.
Why did you plead not guilty?
Because at the same time, like it's like I was paying bills, I was providing for myself at the same time. It wasn't that I wasn't trying to pay him, but it was like, it's hard out there and I wasn't getting paid that much.
Wasn't like you were not trying to pay him, you didn't pay them though, right?
I couldn't pay him. I'd been homeless at the same time.
Okay. The victim of this crime is on with us today, and I would like to have Ms. Miguel speak to the panel.
Good morning.
Good morning.
What
would you like to say?
I was just wanted to say that it was a misunderstanding. First of all, it was it started off as just a heated argument. He did grab me, but it wasn't to hurt me. I don't feel he would hurt me. I've been dealing with Sean for a while now, and this is the first time it ever got that escalated to where we had to even get, call the police or anything like that. And it wasn't intentional that I felt it like I was upset. I was just upset, and emotions and passion. When you're upset, you're drilling and rushes. It just was a misunderstanding. As far as the child endangerment, my daughter was not present for the physical when he grabbed me. She was not there with that. She just was there present when the argument. She entered the room when the argument was escalated. That was the only involvement she had. As far as Sean, he was working, and also he was supposed to start CDL classes with Job One this January, and he was starting that process as well. He was doing good. I didn't want this situation to defer him from being on the right track because he was.
So did you file a false police report? Because
No, it wasn't.
watched
It was
the video.
Yeah, it was.
watched
It
the
was.
video.
I was upset, and he grabbed me. It was aggressively, but it wasn't to where it hurt me. I didn't explain everything at that moment because I was just frustrated and just wanted to just of him to just go at that moment, but I wasn't trying to. I did want him to leave, but he did grab me, but I didn't want. It wasn't to where he tried to physically hurt me. He didn't hit me or punch me or anything of that nature.
And they said strangulation, so
He grabbed. Well,
what-
he grabbed my shirt, and I did have a mark, but to a day or two before that, I was on in the car with a friend, and she had to do a sudden stop, and the seatbelt was around my neck, and I did have a little line going down my neck, and I that probably by me not explaining that because in the heat of the moment that wasn't running through my head. I think that was documented as if he just grabbed the top of my shirt, and it wasn't like a strangulation. It was just a grab and and lift me up. It wasn't a hit or anything of that nature.
okay. We also have Judy Palmer, your mother. Ma'am, if you'd like to make a statement to the panel. I'm sorry, you're on mute.
Good morning. How you doing?
Good morning. Good.
I just wanted to reiterate, Sean was on the right path. He was working at the time this incident happened with him and his fiance, which I don't know what happened, what transpired because I wasn't there, but I'm speaking on his behalf that he was working. And before then, I moved to Texas. And when Sean, I spoke with his parole officer, stating to try, to get him out the environment, living in New Orleans because he no longer have like, immediate relatives that he can, stay with, like far as me, so he can start all over again. His parole officer, gave him a hard time stating that he has to stay in Louisiana. And that's the reason why, he's still in Louisiana, trying to work, But he's been working, he's been trying to be a model, person living in society and, working. Like, I don't know why his parole officer know he had a job. So I don't know why he put that in documentation that he was not working. And, working for a certain company, you don't get paid that much money. And, he even iterated, I told him myself, if I have to, I probably can help you, sometime, pay your fee. But at the time, I'm struggling. He's trying to, start over in society because he's really starting over. So it's not like that he's gonna be able to like pay everything out or give him a big payment. But he was on a path of trying to, pay this his parole officer money. But he was working and stuff. The parole officer knew he had a job. And he was trying to be a model citizen, after, they released him.
Okay. I will let you know it's not the fault of the parole officer that he couldn't go to Texas. There's certain process.
I know
Mr.
I'm sorry, but I had spoke with, the Department of Texas and he would say, they had told me the process and everything.
Okay, good. Okay. Mr. Dennis, have you started an interstate compact to go to Texas?
No, I never received one. Me and my parole officer talked about it. He was saying that he had to send paperwork off to Texas and then take up to 2-3 months for it to happen, for the impact to happen.
Okay, so did you pay the fees for the interstate compact to be initiated?
He never told me about a fee for interstate compact.
Okay. Mr. Where do you want to live?
Huh?
Where do you want? Huh?
Spring Rain, Texas.
So what is your relationship currently with the victim?
Well, that's my child's mother at the time, man. And I love her. I'm not gonna lie. I'm in love with her. So man, we fuss and whatnot, but at the end of the day, like this, I love her.
Okay, so here's the dilemma. If you go to Texas, you can't come back and forth between Texas and Louisiana without permission. So where do you want to live?
Texas.
Texas. Okay. Well, okay, I feel like I know what I'd like to do. So, I'd entertain my colleagues to ask any questions they may have.
Mr. Prater?
Okay, Miss Miguel, is that the way you say your name?
It's Miguel.
Miguel? Miss
Yes.
Miguel, tell me, I'm just curious about the fact, according to the report, you said you told the police he choked you till you almost passed out.
Well,
And
no,
they didn't.
I remember, well, I recall when he asked me, did I lose consciousness or anything? I told him that it wasn't aggressive. I mean, it wasn't forceful enough for me to lose consciousness. He just grabbed me.
But that's not what the report says you told the police.
Well, I don't know if they misunderstood, but my initial conversation that I remember with them, they asked me specifically, did I lose breath or anything? And I described that I didn't. It wasn't enough force for me to lose breath or pass out.
Okay, so you got the marks. You got the marks on your neck and all that from a car wreck?
No, I had one line. It was I was in a car and they made a sudden stop and the seatbelt was pressed on my neck. But it wasn't a mark. It was just that mark on my neck, a line going down.
From a day or two before?
Yes.
Was it a car wreck or just stopped at a
No, it was
stoplight?
almost. It could have been, but good thing she was vigilant enough. She was able to stop it, but it came pretty close to where the seatbelt was pretty, tight around me.
Okay, I don't have any other questions.
Well, I'm just gonna follow Mr. Prater for a moment here. They had body camera on you. They were videotaping everything you said. So we know exactly what you said to the police officer. And it was that no, he did not choke you to unconsciousness, but yes, he was strangling you. And then the other thing was the child. The child was in the video trying to explain what she had seen also. So everything now that you're discounting was exactly what the police officer wrote in his or her report, and it backed up what the body camera showed us you saying to the police officer. So you are telling a very different story than what you told them.
Well, I'm not. I probably was more as far as my daughter saying what she was just expressing when she saw the verbal. She didn't see anything physical. She didn't express anything physical. And as far as me not explaining, I maybe was not verbalizing myself at the moment because I was upset, but I did let them know that I wasn't unconscious. He did grab me by my shirt and the shirt was around my neck, but his hands didn't physically go around my neck.
No, you did answer that. You said that he did not strangle you to unconsciousness, but that he strangled you, but not to the point of
Yeah, that's what I said. I probably
and choking you, and that's what's in his report. So his report is accurate. So really, based upon what you're telling us now about a seatbelt being around your neck, and none of this really happened, is contrary to what you told police officers who were called out to your house last night in fearful that someone was being injured.
Well, I'm not saying that nothing didn't happen. I did. I just wanted to state the fact that I didn't say about the seatbelt or anything at that moment with the cops because it was a heated moment and that wasn't on my mind firstly. And secondly, I'm not saying a different story because everything happened. It wasn't as intense as I probably was very upset. So it was more, I probably described it as a little more intense than what it was because I didn't want this to defer him because it wasn't a situation to where he's violent towards me on a daily basis. This is a norm for me. That's why I just wanted to express that because I don't want that to be a factor of him not being able to be free because that didn't happen that way. I just wanted to convey that. That's why I came, because I didn't want that to be a factor in him not being able to continue to do what he was
Okay,
doing, because he
I
was
got
doing.
you. I got you. I'm going to pass it to Miss Ledoux so that she can speak. And
I'm gonna go ahead and vote because I do believe that there were some violence. The charges have been dropped. My vote today is in lieu of revocation to send you to the domestic abuse battery program within the confines of the Department of Correction. And that will give you an opportunity to start your interstate compact to go to Texas so that you would have no contact with your victim and supervised transfer for your child so that you can see your child, but with no contact with your victim. And so that's my vote today.
So you're revoking my parole?
Okay, so the term is in lieu of revocation. It means you're not totally revoked. You would stay in the Department of Corrections custody until you've completed a 6-month, it's about 6 months, domestic abuse battery program. And then you would be released. And I am hoping that you have your interstate compact taken care of by then, but that you would have no contact with your victim.
Mr. Prater.
Hey, that sounds reasonable. My initial thought was to go ahead and revoke him because I think that lady's lying. And in fact, I think it's pretty evident that she's lying. And I think he's got violent tendencies, but maybe this domestic abuse battery or this will help him by going through this extended period of incarceration. So I concur with Ms. Ledoux, bottom line.
I also concur with Ms. Ledoux because certainly I agree with Mr. Prater also. So as of today, sir, you have been in lieu of revocation, you will be enrolled into the it's a long-term program up to 26 weeks, domestic violence vendor program. And then you would have no contact with your victim. So this concludes your hearing at 9:26.
Okay, friends, so Austin just put in the chat, he wonders if perjury could be applied to a witness in these hearings. So I did some quick research, and here's the answer to that. Usually, yes. The first question is, are they sworn in? Now, we never see them in Louisiana being sworn in on camera, but it doesn't mean they're not sworn in ahead of the proceedings. So that would be the first question. If they are sworn in, then yes, because it's considered an official proceeding, an administrative hearing, so making a false statement can constitute perjury. Every state would punish that differently. The most severe one that I was able to quickly find would be Missouri, where they actually consider it a Class D felony to lie in a parole board hearing. So that's the skinny on that. Okie dokie, let's go back to Texas, Jefferson County. Judge Stevens.
You swear or affirm the information in this document is correct. You can have a seat, just to play back on, right?
Hold on, just a second. What are we doing today on this?
Judge, we literally just got discovery last week. The state just made her an offer of 2 years. Ms. Fontenot would like to consider it and visit with me.
We got some issues here. We're gonna have to take up. Okay. So I'm looking at, first of all, you are Kempa Rochelle Fontenot.
Yes.
Mr. Turk is here representing. I'm looking at the two cases, and they were indicted at different times. The earliest is an indictment 24 CR 2421. And it alleges that on or about October 13th, 2024, in Jefferson County, Texas, you committed the state jail felony of credit or debit card abuse by misusing someone else's Citibank credit card, it looks like.
My daughters want to see my daughters. But no big deal. Because I kind of want to show my wages, having to stop.
Yeah.
Still with Mr. Here's just Stephanie's.
Oh, thank you. Okay. That's the question I'm going to ask. Please go in and back. Perfect.
So police, in that case, on that event, based on that event of October 13th, 2024, filed a probable cause affidavit on November 12th of 2024 after speaking with the defendant, who admitted to using the card, and then that probable cause affidavit was filed into the records on that date, and the defendant was indicted on December 11th of 24. However, after that meeting and discussion and probable cause affidavit was filed, again dated November 12th, 2024, after the police had interviewed the defendant. Apparently thereafter, she goes and misuses a credit card on November 30th of 2024, which would have been about 2 weeks after she had met with the police and admitted to using that credit card. That is what is represented in 25 CR 645, where it is alleged on or about November 30th, 2024, she misused another credit card. These are both state jail felonies, which carry with it up to 2 years in the state jail on each case. What a surprise. I mean, what's disturbing is they caught you, they met with you, thereafter you do it again. You victimize another person just a few weeks afterwards. That's dangerous for people.
Judge, on the 24 case, 24 DCCR, the bond is $30,000. $25 ECCR, it's $5,000.
It's what?
5,000.
Yeah, see, I was like, what? Yeah, it's quite naturally, you commit another offense after you were put on notice and they make a much lower bond subsequent. Well, it's obvious whoever did that must not have been aware of what the circumstances were, because that's preposterous. I mean, that doesn't make any sense. You have to pay a higher price for subsequent mistakes. That's the way the criminal system works. Otherwise, I mean, it would behoove people to keep making more mistakes. They get lesser punishment. That doesn't make any sense. Your bond is going to be changed on that second one. That is obviously an incorrect and invalid amount based upon the findings and what supports the evidence in this case. It's preposterous. And what happened was she goes out and commits the same offense again. And then it's 15% of the value of the previous bond. That doesn't make any sense. So her first bond is how much?
30,000, and on the 2040 CCR.
Your bond, is,
The second one, the 25 UCCR, is 5,000.
yeah, your bond is not 5,000, it's 60,000 on that. It's doubled. It's doubled for the subsequent alleged bad behavior, which is exactly a photo image of what the police indicted you for and what they investigated and met with you and discussed in the first case. So
Judge,
that's the rulings. That's the finding of the court. And you'll be taken into custody until you can post that bond. Plus, you're going to have a GPS device.
Yeah, the GPS check.
Okay, that's good. And you cannot make any financial transactions with any credit cards or any other financial instruments except through the approval of this court. You're dangerous, and other people are being punished because of your actions.
Judge, are you saying she cannot use her own credit cards?
As long as they're her own, but I want to know, she's not charged with that. She's charged with misusing others.
I understand. I just want to be
That's
clear.
why we're here. Yeah, I'm sorry.
Let me-
There's a way to avoid that. Don't commit a crime. It's not a debate, ma'am.
So
You don't get a lesser bond. You can shake your head all day long. You can shake your head all day long, but that defies logic and the law. That's what the ruling of the court is. Her bond is $60,000.
one case or on both cases?
The second one.
So it's 90,000 total.
Yeah. Yeah.
Judge, she's clearly here on an initial docket. She's been communicating with me. She's interested in her case, and the purpose of the bond is not to punish anyone, is to make sure that they show up in court.
I wrote the article on that. I know what it is. Yeah. I know what the purpose of the bond is, but it's also for the safety of the community. Otherwise, somebody can, who does terrorism can post a bond and continue to do that. But where is the logic in allowing people to commit subsequent crimes? I can guarantee this, that misusing credit card hurts the victim far more than it's going to hurt her, because they're stuck with an issue of dealing with their credit worthiness for the rest of their life almost. We all know the way that works.
I think everything was returned, Judge.
Nonetheless, it's in the system.
Well, the defense objects to that, Judge.
Yeah, okay. Your objection's noted, but her bond is now 60,000. What are we going to do before? Hold on. Oh, Kendall, let's take care of the hearing first, and let me finish this before we take her into custody. Okay.
She was saying she had checked herself into
Revive Recovery Center in May. Not for any other reason It was before any of this had come about. It was strictly Judge Stevens knowing where I was headed, where I was going, and the
I'm not
behaviors that I was
following. I
committing.
don't understand what you're saying. Start from the beginning.
I had checked myself. It's not anything to
You're not
make you
finishing any
feel like
sentences.
any type of way or anything like that. I'm just saying, like I've been trying to do everything that I possibly can to do, make sure I start going back in the right direction. Yes, I did start on whenever I relapsed in November.
For what?
And
You're not completing
24
this thought.
And
For what? Do you have a substance abuse problem?
yes, I
Okay,
do, and I
okay.
did, and I've regained back control of that back in May whenever I checked myself in a revived recovery center and inpatient treatment. And whenever I was in Orange County Jail, serving the time on my MTRPs, Judge Arkeen gave me a reinstatement on my MTRP, and I was just in hopes that since I was trying to do the right thing and I was headed back in the right path, that maybe
What were you on probation for up there?
I have in 2017, I
What
got
were you on probation for?
for credit card abuse and burglary of a habitation.
Okay. You're still, and so we're back here with credit card abuse again?
I got
Is that right?
reinstated on, yes, sir.
I think it was in about the same time frame as those judge fees. I don't think they're,
Did the judge in Orange know about these new cases?
Yes, sir.
Oh, well, that's her decision. That's not mine. She can do whatever she wants on those cases that are before her, but generally, people who are on probation for an offense and then there's a motion to revoke filed for committing the same type of offense, they're pretty much dealt with strictly. But that's so when did you go to the recovery center?
Checked myself in May.
Of what year? We're 2000s.
last year.
25.
Last year.
Yes.
When?
May of 25.
How long were you there?
Month and a half. Their program can continue into 3 months, but I only did not continue the program for the 3 months because I had to report to probation.
Okay, so you didn't complete the program.
I did complete the program, the inpatient treatment, yes, sir.
How did you do that? I thought you said you didn't.
No, the whole 3 months, there's 30 days of inpatient, and then you transition into sober living, which I did that as well. And however long you stay in sober living is however long you stay in sober living. That's up to you.
Okay.
It's like she's completed the initial.
Okay, I want the certification of completion. Can you give me a copy of that?
She needs to be out to help you do that, Judge.
No, she's not going to be released except under this court's orders. She's committing crimes while she was on probation, apparently, and while she had committed the same types of offenses.
Would the judge entertain leaving 30,000 for both instead of
The 60 for it's okay. The one is revoked and the bond is 60 total. It's total
for both.
Yeah.
Okay.
Yeah. That's what I do. I revoke and then I accept one bond for all of them.
Thank you, Judge.
But what was the substance abuse? What was the substance you were abusing? I'm sorry?
Opiates.
Did it start with like a prescription?
Yes.
Started with a prescription, Judge. Oh, wait, was it like?
And then what?
Started a prescription of Norcos for a congenital effusion.
And then what?
And then after Norco, I guess the next thing that was available.
Okay, he's muted for a little bit more of a private discussion about that. But while he's muted, couple programming reminders. Sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. We are actually basing at least the beginning of our discussion on the parole hearing we heard from Louisiana at the end of the 4th hour yesterday. So that should be good. And also at the end of the live here today, so about an hour and 45 minutes from now, Michael and I will be premiering our pilot episode of In the Blind. So Michael, friend of the channel, guest host of TCF Live, and sidebar panel member, and I have teamed up. And what we're doing there is not court, although I think we did have a court-ish related topic in the lightning round, if I recall correctly. But anyways, you want to check that out. All you have to do is hang here, and YouTube will redirect you after this show into that premiere. We had a lot of fun filming it. I think it's going to be a great concept, and looking forward to continuing to build that out. This one was pre-recorded, but after this, they'll all be live, so that will be fun. All right, it looks like he's going to stay muted for a little bit. So let's go back to Louisiana.
Today's date is January 22nd. The time is 9:34. My name is Carolyn Stapleton. I'll be serving as the chair today from DOC headquarters in Baton Rouge. My colleagues on today's panel by way of Zoom is Ms. Gerald Ledoux and Mr. Steve Prater. Let's see, our remote location is going to be the Orleans Parish Prison. And will you please introduce yourself, ma'am, with your DOC number?
How you doing? My name is Veronica Marie Porter. My DOC number is 396879.
That's right. Thank you very much. Okay. Do you have a questionnaire in front of you that you would have answered?
Yes, ma'am.
Okay. The way the questionnaire was answered is you do qualify for appointed counsel, which is present today. So with that, we're going to continue on with our hearing. You ready?
Yes, ma'am.
Okay, all right. Let's see, the lead person assigned to your case today is myself, Ms. Stapleton, and I'm going to review your violations, and you can answer guilty or not guilty with a statement. Okay?
Yes, ma'am.
Okay. So, violation for rule number 4. You have engaged in criminal conduct on or before 7/7/2025 when you committed the following offenses: simple battery of the affirmed, violation of protective orders, simple criminal damage to property, criminal trespassing, which was 3 counts, and disturbing the peace. Now, the charges have been refused for those. What do you plead, guilty or not guilty?
Not guilty with a statement, ma'am.
Yes, ma'am. Okay. And then number 10, you have failed to make any supervision fee payments, and you are currently in arrears of $1,134. How do you plead?
Guilty with a statement, ma'am. Nothing
Okay.
guilty because I didn't have the money.
Okay.
Yes, ma'am.
Yes, ma'am. Okay, we have speaking today. I'm sure the attorney, would you like to speak last?
Ma'am?
Ms. Kershaw, you're going to speak last today, and we'll have the other people speak before you in support.
I would like to speak first, and then one ear is on the call now. He could be next, and then if Miss McDonald could be last.
Okay, so the paralegal, is that DeVar's Drain? You want to go second?
If he's allowed to speak, I would love for Javors to speak as well. Yes, and he can go either before or after Megan. Sorry. Yes.
All right, and then she has her son also in support.
So yes, I will go first. One ear can go next. Who is her son? Javors can speak, and then Megan can be last.
Okay, well, all right, that works out. All right, so Ms. Kershaw, will you go ahead and say what you'd like to say?
Yes, thank you all so much. Good morning. I'm Gabrielle Kershaw. I'm here today with Javors Drain and Megan McDonald. Today, we are asking for a conditional release be granted upon Miss Veronica Marie Porter, with those conditions being the ones specifically outlined in the release plan we have today. I'm Gabrielle Kershaw, an attorney with the Orleans Public Defender's Office, and I'm here with Megan McDonald, a licensed social worker, and paralegal Javoris Drain. And also, there's a previous attorney, Adrian Dubois, who also worked heavily on this case as well, and I want to acknowledge his help. We here at the Public Defender's Office are really, really grateful to have worked for Ms. Porter on this case. It's been a joy. For clarity, Ms. Porter pleads guilty with no statement to the fines and fees. She pleads not guilty to the allegation of new criminal activity. First, I want to talk about Ms. Porter and who she is as a person. Second, I will discuss the case at hand. Next, we will discuss moving forward, what her next chapter and what her next steps look like. Finally, I will share my message of support, and then I will pass it along to the other people. Miss Veronica Marie Porter is a mother of four and a native of New Orleans with family that ties back 2 generations. As a child, Miss Porter was primarily raised by her grandmother, who worked 2 jobs to keep the family sustained, with her 2 siblings, a brother and a sister. Ms. Porter is a mother herself. One of her sons is here on the call, and she understands how much family means to her, as that has been the sole focus of her commitment when given the opportunity to be released. As a Southern woman, Ms. Porter loves nature, watching TV, and as a Crescent City native, listening to all styles of music. She also loves cosmetology and hair. At the age of 10, Ms. Porter was diagnosed with schizophrenia and bipolar disorder, as well as paranoia. However, her family has not been able to ever afford consistent and formal medical treatment thereafter the formal diagnosis. All throughout her life, Ms. Porter's grandmother was her primary support system of the family, who stood in to be that support for her mental health needs. When her grandmother died, it became difficult for the family to fill such big shoes that the grandmother once did. Due to finances and quality of life barriers, Ms. Porter has not received formal and consistent medical care for her mental health needs. Rather, the most disheartening realization that we have come to realize as her defense team, Ms. Porter herself, as well as her family, is that Ms. Porter only receives a fraction of that medical attention when she is initially arrested, but not throughout the duration of her incarceration. That is what a pattern that we've seen, and I do want to call that out. Ms. Porter is someone who slipped through the cracks of the legal system and has simply started to become viewed as a number and a case. She is a person with needs that have been unaddressed, in and out of jail because she was not receiving the medical attention she needed, and it just became a repeated closed circle full of unaddressed issues at the root. But today, we are cutting that circuit. Now that we have a release plan in place that finally does address those mental health needs head on, comprehensively, in full detail, Ms. Porter will be in much better hands today than she's ever been if the board gives her an opportunity today to be released. I know that she can do this. I've seen her dedication to getting it right. Ms. Porter poses no danger to the community. In Ms. Porter's words, I want to stand on my own 2 feet and start depending on myself. I quickly want to talk about the case at hand. The case at hand is one that's been no prosecuted by the Orleans District Attorney's Office. This means, in short, that the case is closed with no conviction rendered, and the DA made that choice on their own. The case itself alleges Ms. Porter violated protective order, civil criminal damage to property, and battery of the infirm. These charges did not stick for a reason. Ms. Porter is going to continue leaving Ms. Crawley alone, as she's been doing. Ms. Porter has also made the very tough decision to leave her husband alone as well, Michael Boxey, as she has made the decision and come to realize that if she focuses on herself and puts that investment into herself as a priority, she's even closer to retiring from her previous life, putting it permanently behind her, as well as all of the influences involved. Other considerations that were made when the DA decides to no prosecute a case is also the background of the cooperating witness. Ms. Crawley also has a criminal history herself involving drugs. There's nothing to corroborate and prove beyond a reasonable doubt that any of the allegations in this police report are true and could be proven at trial. So these are all of the considerations that the DA has made when they make a decision to no prosecute the case as they have done in here. Ms. Porter is not a danger to the community. She wants to turn her life around, and we as her legal team are asking for her to have the opportunity to do so. So moving forward, Ms. Porter has a release plan. I want to let Megan discuss it in full detail. Megan is one of our best social workers at the Public Defender's Office. But I just want to say really quickly as well, Ms. Porter has expressed her desire to work with our Public Defender Office on other resources that we had outside of the release plan itself. I know she wants to get this right. I would like to know a vast majority of public defenders' office across the nation do not have social workers, which makes us very grateful to Megan. So when we have clients, I have hundreds of clients, when we have clients who want to take control of their lives and use the resources around them by saying, hey, even though my case is closed, or even though I've gotten released, I still want to work with you all. Ms. Porter has said that. And so for her to share that with me, that shows like her deep commitment to wanting to get this right. And I do want to point that out in favor of Ms. Porter. Quickly, I just want to talk about my relationship with Ms. Porter, my message of support before I pass it to everyone else down the line. Since being on this case representing Ms. Porter since October of 2025, I can genuinely say that Ms. Porter is such a sweet and loving soul. I remember when I first came to meet Ms. Porter in October, she had been incarcerated for well over 4 months at this time. She expressed how sad and alone that she felt, and it hurt because I couldn't touch her. I couldn't give her the hug that I knew she needed. She is still a human that feels things and feels them even more intensively due to her condition. The pain that was in her voice, the confusion, and at the end of our meetings, I would actually put my hand on the window, and she would put her hand on the window, and that was our way of connecting. Ms. Porter needs that connection. She will always say, thank you for treating me like a human. That's because Ms. Porter is one, but she's used to not being treated that way. In my words, I'm sincerely asking for the parole board to not demonize Ms. Porter for her mental health. Ms. Porter only has love in her heart, and she's very passionate and means well. She's not a danger to the community and cares about New Orleans as well. This is a community that she's from. She takes pride in this community. And Ms. Porter has shown her grit and dedication to being a better person, continuing her motherhood. And her family have gone great lengths to be supportive, reaching back out frequently to see what they can do to be that support system for her. Anything they can do to help, they've always been there to let me know what I need or to give me what I need to work on her case. This is a big day for everyone. Ms. Porter has a 99-year-old grandfather who is not here today because he is a little older and he's probably asleep right now, whom she's very close with. And this is the husband to the grandmother we mentioned at the very beginning. She wants to continue to spend time with him in his last few days. And that's something that's also really, really important for her. So while Orleans Parish Jail does not offer much opportunity for classes and training, I do want to say that she's been a self-starter in speaking up for this parole packet and this release plan, and is really trying to take control of her life. I see it in her soul that she's committed to adhering to her parole conditions. I also lastly just want to note, Ms. Porter has been incarcerated since July 2025 with no infractions or other disciplinary actions while in Orleans Parish Jail. Ms. Porter is often confined to her 5x5 cubicle for 23 hours a day without daily showers. And with her mental condition, that's not the best conducive environment for her. And with her age, it's also not the proper environment for her. This is Ms. Porter's opportunity to receive these services now. She's in the best hands now than she's ever been. And I don't mean that in a hyperbolic way. I mean that in the most literal sense. I want to make sure that she's able to obtain and access these resources now, since they're so comprehensive. She has that support now, and it would make sense for her to access them now. Ms. Porter takes ownership of her mental health. She acknowledges that her mental health contributes to this cycle with the law, and she takes ownership of that and wants to take control of her life by taking control of her mental health. I know she can. Many prayers, lots of love, tears, and real love have been put into this packet and this release plan leading up to today. I hope you all hear us, all of us, and I would love to turn it over to the family. Thank you so much.
I'm gonna ask you a question real quick before we turn it over to the family. Okay, referring to the husband between these two women. But she has a different name from the man listed in the police report. Are they actually married? What is the status there?
My understanding is that they've been together for 11 years. So there's been a very, if not legally married, there's a common law marriage. They're together. They've hold themselves out as to be a married couple.
Okay, and he's also involved with Miss Crowley, who is listed as the victim. And he must be staying with her or something because that's causing her to be going over there
Yes.
for some things.
So my understanding, and also it says in the police report, when Ms. Porter was incarcerated, they had Miss Crowley and Mr. Boxey had engaged in some type of informal relationship, which did, cause a bit of a disagreement between Miss Porter and Mr. Boxey. But that's my understanding is that like I don't know if they were staying or living together, but there was some type of fling going on.
Okay, I just wanted to make sure I was dealing with husband and wife and, an extracurricular activity, or if if she was really actually separated from him. And he was,
They've held themselves out to be married for over a decade, yes.
right. And who would you like to move on to next, ma'am?
Wanier Porter, who is her son. Thank you so much.
Thank you. Mr. Porter?
Hi, how are you doing?
I'm fine. How about you?
I'm all right.
What would you like to say for your mother today?
So I'm gonna start off with my introduction, obviously. My name's Wanda Porter. I'm Veronica's son. And all I can say is throughout the entire time period of me knowing my mother and actually getting to know her as a person and everything, she's nothing but full of love and joy and care. And every time we speak on the phone, the main thing she tells me is she can't wait to come see me. She wants to come and reunite with me and the rest of her kids. She wants to try and find the best way she can to get us all back together, even though we are grown now. But she obviously, as a mother, you would want that family again. You would want that family intact and having everybody in one spot. It kind of makes you feel better. And at the same time, just to kind of piggyback off of what Gabrielle was saying, if she's home and, in the presence of people that love and care for her and not just a building that looks at her as a number, she has a very high chance of getting the help that she needs for her mental conditions, for the certain health issues and things that she has, so that way she can have the right hygiene, have the right help, have the right resources, and it'll be a lot more tangible in the moment rather than being incarcerated.
I'm going to interrupt you. It looks to me like you're in the passenger position. That's why I didn't ask earlier, but you are not driving. Am I correct?
Oh, no, ma'am. No, ma'am. Absolutely.
I didn't think so. It looked like you were on the passenger side, but we do need to. Okay, so for everybody's peace of mind, you're a passenger. Okay,
Yeah.
Go for it, please.
Yeah, I'm in the passenger side. No
I
pedals
got
over
you.
here.
There you
Yeah, no
go.
pedals on this side.
All righty, go right ahead, sir.
Oh yeah. So where was I? Yeah, she'll be able to get the help that she needs. And me as her son, obviously I'm gonna have a stronger feeling of wanting to help because that's my mother. I obviously want her back, and I obviously want her to have an opportunity and the chance to do things the right way. Everybody deserves a second chance. Everybody deserves an opportunity. And I feel like if you're not given that opportunity, how do you ever find out if you're able to show what you're talking about? Because actions speak louder than words. And if you're not given the ability to complete the action to follow up with the words, then it's all futile.
Let me ask you something. Where do you live as compared to where your mother lives? Or do you live in a different city, state, or that has kept y'all apart physically?
Yes, ma'am. I live in Houston, Texas.
Okay, all right, all right, all right. Did you have anything else you wanted to say?
Um, honestly, no, I think that's about it. Yeah.
Okay, you love your mother and that if she comes, she'll have family support, which she does need. There's no doubt about that. Okay, thank you very much, Mr. Porter. All right, we're gonna go next to, the paralegal. Is that who you would like to speak? Ms. Drain?
Yes, ma'am. Good morning. Sorry about that. I was muted.
Oh, that's okay. Thank you.
Yes, ma'am. First of all, I want to say good morning to everyone. Thank you to the team. And I want to get started by saying this. Thank you for the opportunity to speak. I am here in support of Ms. Porter. The conduct that led to this revocation is closely tied to her ongoing mental health struggles. It's not a refusal to comply or a disregard for the court's authority. Since this incident, the related criminal charges have been no processed, which reflects that the case itself did not move forward. Ms. Porter has a documented history of mental health needs, and when she is properly supported and engaged in treatment, she's able to comply and be stabilized. What is different now is that those needs have been clearly identified, and there's a concrete release plan in place to address them. Continued custody does not resolve the underlying issue, but treatment and structure that are mentioned in the release plan will. Ms. Porter understands the seriousness of being on supervision and takes responsibility for her obligation. She is asking for the opportunity to continue her parole in the community with appropriate mental health support rather than being punished for symptoms of an illness. We respectfully ask the board to consider her mental health context, the fact that the charges were not processed, and the availability of community-based supports in making this decision. Thank you for your time and consideration.
Thank you. Okay, now we're gonna go to, Miss Megan to speak to us, the social worker.
Hi, my name is Megan McDonough. I'm a licensed clinical social worker with the Public Defender's Office. And I just wanted to highlight the release plan that Ms. Porter and I have put together that I believe addresses all of her complex needs, beginning with an assertive community treatment team, which is the highest level of mental health care available in the community. They will provide her with both a psychiatrist and additional caseworkers and come to her, eliminating the barriers to medication access related to transportation. They aim to see the people enrolled about once to twice a week. So she will have a consistent team around her. In addition to that, she has been referred to FAIR, which is a part of Disability Rights Louisiana, to address her employment struggles and getting her SSI turned back on so that she can have income and be stable. And the last referral that I've made is Operation Restoration, which is a reentry service here in New Orleans that will help her get back on her feet by providing things like a phone and peer support. I believe this wraparound service, including me, because I will be facilitating all of these referrals and stick with her until she is stabilized, will address her needs. Thank you.
Okay, I've got a question for you.
Yeah.
Okay, is she gonna be in a controlled environment? Because with all of that said in between, and we do know we're dealing with, as y'all have said, a severe mental health issue. And will that be a controlled environment? Because a lot of people with mental health, they will wander around, they will get thoughts in their heads, as compared to a structured environment. And, you know, some people are in nursing homes or hospitals or something like that. So is she gonna be living independently where?
So currently she'll be living with her grandfather while we get her income back on. I think A group home placement is something that we can discuss, but only once she has income. And right now she'll be living with her family.
A group home. And so you were talking about SSI, Medicare, Medicaid, they're gonna help her with all of that also?
Yes.
Which would help pay for her
Yes.
to go to the facility.
Yes.
Okay, well, I'm going to talk to the attorney now at this time. I know everything was nonpros, but it looks like, you know, there was a severe issue with jealousy, and there were threats and different things like that. And the mental health issue is something that I'm very glad, I'm very impressed with everything y'all are talking about, you know, the treatment team, and that people are going to come to her and they'll lay eyes on her housing and the condition that she's living in, because, you know, when those things start going down, that's an indication of where her mental state is. Will you have the ability to intercede if you see something, or the different team, the FAIR team and the Operation Restoration? Will somebody in there have the ability, if they see her not doing well, to have her OPC or PEC? Should that be
Yes,
necessary?
the ACT team, because it includes a psychiatrist, has the ability to OPC people if they deem it necessary.
Okay. And so the ACT team is going to be part of this biweekly visit, or just
Yes.
referral?
No, they are the people that will be be visiting her at her home. It will not always be the psychiatrist. I think like sometimes the nurse practitioner will visit her, but between the whole team, they will lay eyes on her once to twice a week.
And of course, twice a week better in the beginning, you know, because we do have a real problem. And I don't demonize mental health, and I do know that mental health problems lead to other problems. And so, I don't have any further questions. Do you have any questions, Ms. Ledoux?
I would like to speak with Veronica myself. I've heard from everyone else. I'd like to speak to her.
Okay. Veronica.
We don't see you on camera. Is there anyone who can
Yes, ma'am. I'm going to call her right now. I need help.
She's there. Something is wrong with their camera, so it's gonna come in and out.
Okay.
They're coming.
Okay. Miss Veronica, She coming
right now.
Okay, I'll skip it. I'll skip it. Thank you.
There you are. Okay, Miss Veronica. Miss Ledoux.
Okay, Miss Veronica.
How you doing, ma'am?
Good. Tell me, how do you feel about not seeing Mr. Boxey and staying away from the other lady? Tell me how you're thinking about that.
If I knew then what I know now, ma'am, none of this would happen. My plans are not to see Mr. Boxey or Miss Crowley ever again. I want to have a purpose in life, and I want to stand on my own 2 feet. Even though I qualify for disability, I don't want to depend on it. I was told that I can work 4 hours a day, part-time a week. So I want to earn my way through life, and earn my stability. And I want my grandpa and my mama to be able to depend on me, and not me just depend on them. I'm very stable now, and I'm well aware of everything that's going on, and I plan on staying this way.
How long were you incarcerated before you were released in December last year?
2 years and 9 months.
Okay. Have you spent a lot of time in prison, or how much time have you spent in prison total?
Well, I did a lot of time. I've never done more than 2. This is the first time that 2 years and 9 months was the longest I ever did. But even though I did 2 years and 9 months, what I've learned now from my social worker, I didn't learn all of that. All I was ever told whenever I went to prison was that I qualified for a check. So I was always dependent upon a check. Now I know that I can earn my own stability, and that's what I want. By me earning my own stability, it gives me things to do, like opportunities, and it gives me a chance to have an address and a paycheck, not a DOC number.
Okay, that sounds like you've got your mind straight. How compliant are you with taking your medication whenever you have medication? Do you take it or?
Ma'am, I'm very compliant with it. That's why I'm not able to work full time. I have to work part time. So I want to work part time. I want to work, period. It gives me something to do.
Okay. I don't have any other questions.
Mr. Prater?
Where were you living when this problem occurred with this other lady?
At 828 Orange Street, sir, by my grandpa.
And that's where you're going back to, correct?
Yes, sir. That's all the way across town, which is where I be whenever the police is being called. I'm in that area, 828 Orange Street.
And how old is your grandpa?
Almost about 100, if I'm not mistaken. I think he's almost 100.
Okay. I don't have any other questions.
Well, I'm going to follow up on what Mr. Prater just said. Okay, so where this happened, you're going right back to.
No, that's not
and
where
we're
it
going to
happened.
have a no contact situation here.
You
had didn't you have a protective order? You weren't supposed to go around this lady?
Can I clarify,
Yes.
Sorry, Ms. Stapleton, I just wanted to clarify.
Please do.
Where this allegation, the address is the CW's address. It is not, Ms. Porter's grandfather/grandmother's home. It happened at Crowley's address. That's where this allegation.
All right.
It has not, so just wanted to clarify that.
And she won't be living near this,
Yes, they do not live near each other.
Okay, because that wouldn't be
They do
good.
not live near each other.
All right, so you do understand that's a no contact. That's, you stay away from both of them.
Yes.
And I know that the compliance is there if you have your medication, but that's been spotty on and off, the ability to get your medication. And if you haven't been on insurance and your SSI was cut off, that medication is extremely expensive. So a lot of people need their medication, cannot get it. But from what I understand with this ACT team, they're going to see to it that you get the correct medication.
Yes, ma'am.
Yes.
And you're on board with everything that you've heard said today?
Yes, ma'am.
Be twice a week, and you'll do what they asked you to do, and you'll be available for visits and such?
Yes, ma'am.
Okay, somebody wanted to say something? Megan wanted to say something?
I just wanted to say that she will be released from the jail with medication. And if she's not, I will be able to coordinate. So if there is any lapse in insurance, it will not cause her to go without any medication.
Very important. I would like to call for an executive session at this time, please. Ms. Lagoon?
Yes.
Stapleton?
Yes.
Prater?
Okay, the Louisiana Pro Board goes to executive session. So while they do that and we await the outcome, let's go back to Judge Stevens, new contestant.
Ms. Williams, yes. I've been talking with the state about a possible resolution on this case, and I think we can get it resolved. We just need
a few weeks.
How much are we talking about?
3 weeks, 4 weeks.
3 weeks. Yeah, okay. Done. Thank you. We said 3 weeks on this. Please get a resetting from that lady. Thank you. Timothy Cater.
I'll shoot you.
Mr. Maitland?
Get here, that's a plea.
Get here. I'm gonna need some files.
Yes, I'm sorry.
It's all right.
Marvin, give me just a second, okay?
No problem. My
And
client
he
is
needs to
just.
come square in front of me.
James, your client is where?
Oh, what?
Is that you?
What's right there?
He's right behind you.
I'm
Surprise. Oh, you need to see this lady. She's gonna swear you in, sir. Thank you.
Yes, sir.
Marvin, how long are we moving yours? Okay. You sign on the highlighted X for me, please. I know what mine is. Mr. Cater.
Hey, Marvin, take care, buddy.
Your 75?
Yes.
Okay, and your right thumb print. Place it flat right there on top. Keep that one more time. And place it right there. There you go. You just need to judge you.
25 CR 400 is now called the State of Texas versus Timothy Cater.
Cater, Your Honor.
Cater?
Cater, yes.
Cater, and you were here with Mr. Macon, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment
Yes, Your Honor.
and the arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about February 2nd, 2025 in Jefferson County, Texas, you committed the state jail felony of being involved in a collision which involves injury to another. And apparently you intentionally and knowingly left the scene of the accident without following the rules of the law and providing information. This is a state jail felony. Do you understand what you were charged with, sir?
Yes, Your Honor.
Was what happened to the other driver?
They went to the hospital and were released, Your Honor.
That's
What do you
correct,
know?
to my knowledge. There was some injuries, but nothing
What were
severe.
the injuries to you?
Grapes and abrasions.
Well, because the indictment says it resulted in serious bodily injury. Is that not wrong?
Well, with them going to the hospital and
I'm listening intently how you're going to explain this one. Grand jury is saying something different from what you're saying.
well, from the information I have, Your Honor, they just were kind of bruised and shocked and all of that. They were on a motorbike that was weaving in and out of
Oh, you understand what you're charged with?
Yes, Your Honor.
This is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be pleading guilty Be placed on deferred or unadjudicated probation, which can be up to 5 years in length, fined $500. And what is restitution here?
We will have to determine probation.
Restitution, which is to be determined, we're going to have a pre-sentence report done anyway and prepared. That will, or a post, we'll figure it out here in a minute. And the court needs to know if and how much restitution is involved. That will be a mandatory condition of probation. Do you understand?
Yes, sir.
Your Honor, I've been given information that Mr. Bennett is hiring a personal injury lawyer to sue Mr. Tiff.
That's correct, Your Honor. There is a civil suit pending between these parties as well.
That only meant a lot to me. In criminal, I'd be worried about it, but I'm going to make my own findings, and he will be given credit for whatever it's the civil side does, whatever that may be. But restitution is going to be ordered by and through him in some way, or through his insurance representatives. But they're not the one liable. They're liable to him. He's liable to the victim. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked at State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all proven correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial. Rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is pre-sentence report waived on this?
We'd waive it, Your Honor.
Okay. If nothing further, I'm going to make the findings that you are mentally competent to enter this guilty plea. It is freely voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to follow this plea agreement and defer any finding of guilt. Postpone so long as you follow the terms and conditions of probation. In this probation order, you will be placed on probation for 5 years. You do well, it can be shortened to 1/3.
Yes, sir.
There will be terms and conditions of probation. The probation officer will go over with you. The one thing that we don't have, there's a $500 fine among other conditions, but the restitution with it, which is going to have to be determined later upon more investigation on this through the probation office's efforts. But that will be your responsibility. If there's an issue of how much it is, then thank you. If there's an issue on how much it is, then the court will resolve it in a hearing that where all parties get to be heard. Okay. Anything else? So please see probation. Thank you.
That lady right there been waiting outside.
All right, let's head back to Louisiana, see how this thing finishes up. There we go.
Ms. Porter?
Yes, ma'am.
We're back from executive session. We need somebody to call us back in. Okay. Okay.
Yes, ma'am. I'll make a motion. We go back into regular session.
Thank you, Mr. Prater. I second. And the time is 10:20, and we're back in regular session.
And for the record, I am here. I can't start my video. All my attempts to start it have failed thus far.
Okay. All right, well, we can hear you, Mr. Prater. Thank you very much.
Okay, now the
Oh,
host
now we
allowed me.
see you. Okay, all right. Okay, well, at this time, I'm prepared to vote. And the panel will vote. Ms. Porter?
Yes, ma'am.
I'm very supportive of everything that you said. The problem is for me that you are an 8th class offender. And, you do, I know that some of the stuff was not crossed, but you are an 8th class offender. And, at this time, based upon that and based upon the fact, I heard them say that you're in lockdown 23 hours a day. Is that correct?
Yes, ma'am.
Yeah, see, you won't be like that. When you get out, you'll have your freedom back. And before, when you had your freedom back, you committed crimes. And I'm not demonizing mental illness by no means. And I think programs that they have set in place for you will be wonderful. And I hope that they will stay and continue to be a part of your life and help you wherever you're located at. But today, my vote, I'm gonna have to revoke you today. Ms. Ledoux?
My vote is also to revoke and to be placed in a DOC facility that will provide continuing mental health support.
Okay. Mr. Prater?
I concur.
Okay, so at this time, Ms. Porter, have been revoked. I do concur that you should be placed in a DOC facility that will provide continuing mental health support, which I think has been spotty. So that concludes our hearing at Orleans, and the time is 10:23.
Okie dokie, friends. 4th hour time. TCF overtime. So I don't know that there's a whole lot that we saw during the day from these cases that would spark huge amounts of discussion. But if you have anything you want to talk about regarding today's cases, obviously, if you're a channel member, you can phone in, go to the Discord, and you will find a link there under the members section. For you to get at that section, if you're a channel member, you need to make sure that your YouTube account is linked with your Discord account. That pulls all your privileges over and allows you to get the link to join me here on the show. And oh, by the way, you don't have to join with your camera turned on. So if you just want your voice, you can do that. Lily asks, do they ever vote to approve? Yeah, quite often. Especially of late, it feels like I've seen more approvals than normal. And the reason why I go to the board, well, a couple reasons. One of them is that it's, they're good stories. They're intriguing to kind of follow along with. But you also never really know what this board is going to do. They confound us, they baffle us, but I will also tell you that I give them all the respect in the world because they put themselves out there every time and they never take their stuff down, unlike many other judges that we see, where they'll put themselves out there, but they'll mute during certain times and then they'll immediately pull their stream once it's done and all that. These people don't do that. They leave their work out there for all the world to see, good or bad, and I do respect them for that because it's not always the norm in the LawTube space for that to happen. So good on them there. Now, I do have a couple of things that are worth discussing today. One of them I'm kind of passionate about, so if you would like to express similar or dissenting passion once we get there, again, feel free to call in and talk to me because I would love the debate. Programming note, again, at the end of this hour, you will automatically be directed to the premiere episode of In the Blind that will premiere at 11 a.m. my time, so 11 a.m. my time, so 1 p.m. on the East Coast, 10 a.m. on the West Coast. And that is set as a premiere, so there will be a live chat feature going on, and I'll be present in the chat, and I'm guessing Mike will too. So join us for that. We had a lot of fun filming the pilot last night, and that's what we'll be showing you. And I think it's going to be a great show. Different from what we do here for sure. But if you like Mike and you like me, I think you'll love this show. It's a lot of fun. And then also reminder sidebar tonight at 8 p.m. East, 5 Pacific, where we're going to talk about some parole board stuff. Not the case we just saw, one from yesterday, but still worthwhile. So I'm going to start us off with something that is lighthearted / slightly baffling, because I just can't believe that this actually happened. So this is from CBS News. It is basically the real-life reenactment of the movie Catch Me If You Can, which was based on a real-life thing. But ex-flight attendant got hundreds of free flights posing as pilot, and current flight attendant, Justice Department says. So, former flight attendant for a Canadian airline posed as a commercial pilot and as a current flight attendant to obtain hundreds of flights. Dallas Pokornik, 33, of Toronto, was arrested in Panama after being indicted on wire fraud charges in a federal court in Hawaii last October. He pleaded not guilty Tuesday following the extradition. So I would have written that as he pled not guilty. We had that whole pleaded pled debate. I think that was on Sidebar the other day. I like pled myself. But we looked it up. Both are correct. If convicted, Pokornik faces up to 20 years in prison, a fine of $250,000 plus a term of supervised release. According to court documents, Pokornik was a flight attendant for a Toronto-based airline from 2017 to 2019, then used fake employee identification from that carrier to obtain tickets reserved for pilots and flight attendants on 3 other airlines. U.S. prosecutors said Tuesday Pokornik even requested to sit in the jump seat, that's that extra seat in the cockpit, typically reserved for off-duty pilots. It wasn't clear from court documents whether he ever actually rode in the plane's cockpit, however. Indictment didn't identify the airlines except to say they're based in Honolulu, Chicago, Fort Worth. Representatives for Hawaiian Airlines, United Airlines, and American Airlines, which are respectively based in those cities, didn't immediately respond to emails from the AP seeking comment. Air Canada, based in Toronto, didn't respond to an email seeking comment. Scheme lasted 4 years. U.S. magistrate ordered Pokornik to stay in custody. His federal defender declined to comment. So nobody wants to comment on this thing, which implies to me it was very prolific. So yeah, in 2023, an off-duty airline pilot riding the cockpit of Horizon Air said, "I'm not okay," just before trying to cut the engine's power mid-flight. That guy later told police he'd been struggling with depression. That's not related to this. I'm not sure why they added it other than to say that having somebody in the cockpit who isn't actually flying the plane is potentially a safety risk. But this one just caught my attention, number one, because it mirrors the movie Catch Me If You Can, which if you've never seen it, Tom Hanks, Leonardo DiCaprio, Leo plays Frank Abagnale, I think is how it's pronounced, who is a real-life person who did things like impersonate being an airline pilot and use that to gain free flights across the country, and that was just part of his shtick. But interestingly enough, he actually started working for the FBI to help hunt down people like him. He used to write bad checks, and I think at one point he pretended to be a doctor. All sorts of weird things with him. But an actual modern time reenactment of that. What's scary, though, to me is the fact that he got away with it for a few years. What does that say about the security of our airlines, that somebody can come up with credentials like that and fake their way into the jump seat of an airline cockpit? I'm just saying, not sure I'm a fan of that one. So that's kind of my lighter story. This is the one I'm a little more passionate about. And again, I would love your comments on this one once I'm done ranting, perhaps. So I'm sure we all remember Uvalde, and that was the school shooting where a whole bunch of children were killed. And that one has been debated right, left, and sideways in the media because of law enforcement's, in my opinion, complete failure to act quickly. So when that shooting went down, they weren't quick to take out that gunman, and a whole bunch of kids died because of it. But the school police officer, the one who was assigned to the school, was in trial, and they reached a verdict on that trial. Specifically, a jury returned a not guilty verdict Wednesday evening, so this was last night, in the trial of former Uvalde school police officer Adrian Gonzalez, charged with 29 counts of child abandonment or endangerment tied to that 2022 Robb Elementary shooting. Jury deliberated for only 7 hours before returning the verdict. Gonzalez faced charges tied to the early minutes of the attack. 19 children and 2 adults died in the shooting, which is the deadliest in Texas history, according to the Texas Tribune. His counsel brought up 2 witnesses to stand in his defense. Gonzalez did not take the stand. Speaking to the press after the verdict was read, both Gonzalez and his legal team shared details of their conversation with the jury. Defense attorney Nico LaHood said the jury told them there were, quote, a lot of gaps in the evidence. You can tell they say there were gaps in the evidence, said LaHood. They appreciated us bringing out those gaps. They considered everything. They were very diligent. They worked very hard back there. They were very mindful and deliberate. Obviously, they were saddened because they know that the other families are mourning still, but they said there was a lot of gaps in the evidence, and some of that didn't make sense to them, LaHood added. On Gonzalez's part, he thanked God, his family, his legal team, and the jury after being acquitted. First things first, I want to start by thanking God for this, Gonzalez said. My family, my wife, and these guys right here. He put them in my path, you know. I'm thankful for that. Thank you to the jury for considering all the evidence and making their verdict. When asked if he had anything to say to the Uvalde families, Gonzalez responded, no, not right now. Former Uvalde Police Chief Pete Arredondo was also criminally charged in relation to the 2022 shooting. He's charged with endangerment and abandonment, pled not guilty. The date for his trial has not been set. So I bring this up because obviously it's a legal thing, and it is very much court thing, and it's also very much a national piece. I mean, this is something that we all saw, we all lived through, and mentioned straight out. I'm one of the people that shook my head at the police response to it. And I take huge issue with the verdict in this one for a few reasons. Now, if our friend of the channel, Bailey, were here, he would tell me that he has faith in the jury, and the jury never gets it wrong. I'm not sure the jury got it right in this case. Because, let me find it here. This is a witness. Last name of Flores. Flores is a key witness for the state, providing the only first-hand testimony about what Gonzalez did or didn't do in the first few minutes as the shooting began. Flores said she fell after seeing the gunman, and as she got up, a police vehicle drove up to her. She told the officer 2 or 3 times where the shooter was headed. I just kept pointing. He's going in there. He's going into the 4th grade building, she said. He just stayed there, she said of the officer. He was pacing back and forth. So that ultimately is my challenge that I have in my mind with so much of this situation. We had a deal there where you had an active shooter situation, but the police refused to move in on it until they had what they felt was sufficient numbers and a good tactical position to be able to take on the shooter. And the first guy on the scene, who was Gonzalez, the officer assigned to the school, did not take any action on his own either. If this witness is to be believed, he was more in paralysis than he was at a point where he would take actual action to help these children. That says so many bad things about where we're at. If I may be blunt, if you are in law enforcement, if you are in that position, if you've taken that job, and we can debate how much they're paid and how much stress they're under and all of this kind of stuff, and those are good debates to have, but two things can be true at once. They can be underpaid and overstressed, but they still signed up for the job. And their job is to throw themselves in harm's way at a moment's notice to help those that they've committed to helping. Period. End of discussion. In my mind, anyways. And what happened here was they didn't move in. They waited until they had what they felt were sufficient numbers, until they had what they felt was a good tactical position, and then they decided to take action. Meanwhile, the people that they are sworn to protect died. And I don't think that says a lot about our law enforcement, unfortunately. And I'm not an anti-law kind of person, but I'm also not exactly pro-law either. I'm somewhere in the middle, and it's probably based on the fact that there's a whole lot of law enforcement that are out there acting a fool, but honestly, there's a whole lot of public out there acting a fool, egging them on, trying to get them to do bad things. So there's problems on both sides. But especially in this case, when you are sworn to protect, in this instance, children, you got to go in there and do it. And I'm sorry if it's not a good tactical position for you. I'm sorry if you're fearful for your life. I don't care, because that's the job that you decided to take, that you swore to do, and you didn't do it. And really what it tells me, if that is going to be the case, then I would question our ability to count on law enforcement to protect us. Honestly, I've always questioned that ability because the response time's too slow. By the time the police get there, in most cases, whatever was going to happen has already happened. So they're there to investigate and clean up, much more than they're there to prevent a crime from happening. But in this case, there was an officer there who might not have prevented the first shots, but could have ended it sooner, and he didn't take action. And then we have a jury that somehow looks at this and says, yeah, no, it was cool. I don't know how. Now, obviously, I was not in that jury room. I don't know what they were presented with, but the fact that we know that the officers delayed in their response to this event and kids died for that, it had to be some really compelling evidence, or some really compelling holes in the evidence, as they put it, to keep some kind of conviction from happening there. Dude didn't do his job and people died. I don't know. I would be anxious to hear from some of you if you have other thoughts on the matter, but I am really bothered by that result. I don't think juries are perfect. I don't expect them to be, because we're human beings, but I'm absolutely shocked at that outcome. I really am. I'm baffled by it. I would not have expected, with all of those dead children, for them to look at an officer who, from the looks of it, froze in the moment rather doing his duty, and they're just like, yeah, it's cool. It's fine. It's no big deal. I don't know. But I'll move on to a couple of other things, and you call in and talk to me if you feel differently about it, or if you feel the same and want to just echo my sentiments. It's totally up to you. But there's a couple of news stories we can cover in the meantime, so we'll do those. So This is also from CBS News, something that I found interesting. It doesn't have to do with the United States, but it has to do with a drug operation in Europe. And this is also from yesterday. European police said Wednesday they busted a major synthetic drug ring working across several counties in the largest ever operation of its kind, several countries, striking a massive blow to organized crime. Authorities dismantled 24 industrial-scale labs and seized around 1,000 tons of chemicals used to make stuff like MDMA, amphetamine, and meth. Quote, I've been in this business for a while. This is by far the largest ever operation we did against synthetic drug production distribution. I think this is genuinely a massive blow to organized crime groups involved in drug trafficking, specifically synthetic drugs. The profits generated were considerable, police said at a press conference in Warsaw. For every euro spent on drug production, traffickers made approximately 30 euros in profit. Well, yeah, a 30x return on your investment. There's no surprise then why so many people get into the drug trade. That's better than the stock market on most days. I don't know if it's better than silver, though. Silver's been running way up. A year-long operation involved police from Belgium, the Czech Republic, Germany, and the Netherlands, Poland, and Spain. Agency released a video of operations showing officers conducting raids, making arrests, and seizing evidence. Europol said police conducted 50 house searches, 45 in Poland, 2 in Belgium, 2 in Germany, and 1 in the Netherlands. Well, Mrs. TCF won't like the fact that 45 of the 50 were in Poland because she's half Polish. That will make her sad. More than 85 arrests were made, including the 2 suspected ringleaders, both from Poland. This surprises me, too, because Poland, at least politically, has gone very conservative. But that might be... So it surprised me that the crime is there, but in that kind of crime anyways is there. Conservatives have crime too, but it's normally not drugs. But that also might be part of what this is about, is if the more conservative government over there made this a priority to crack down on. I don't know. I said crack down on, like crack, like the drug. These precursors were legal, generally used in the pharmaceutical industry, but the quantities acquired and the processes were very large, unrelated to the actual needs of the companies acting as fronts for the trafficking. So that's how they caught them. Very interesting stuff. I brought that up because it kind of proves that we don't just have problems here, we kind of have problems everywhere. I like your background, Michael.
Yes. Yeah, it's such a great background. Maybe I'll just get out of the way. There we go. Nothing like cross promotion.
Advertise much?
Yes. Well, hey. So I'll tell you what, Dan. This is a great time for some advice. Diversify your portfolio. I'm going to invest more. This is a big time to invest in meth and cocaine and silver. I think
30 to 1. Yeah.
Yeah. I don't know. I think it's worth it. Might be worth the, whatever. So I'll tell you.
I don't know, though. That barely outpaces inflation.
Boy, I know. Yeah. I can try to go out. Yeah, I bought groceries the other day. Tell me about it. So, I'll tell you.
The loan went through then?
Yeah. Yeah. Luckily, they only wanted one arm. And that's
cool.
That's good. So, yeah.
Not bad.
So I gave him the left because I kind of need the right arm. They grow back, right?
Oh yeah,
that's what I've heard.
Absolutely.
Okay.
Actually, just fun fact: what is the one part of your body that will grow back completely like it was before?
The liver.
Do you know?
Yeah, it's the liver that'll do that.
Okay, the one part of your body that you can see.
Oh.
Okay, the one part of your body that you can see.
The hair. Well, not my hair, but some people's hair.
Fair enough. No, your finger in front of your nail. If you cut off the very tip of your finger, it will completely grow back.
That happened to my buddy Roy. He was walking his dog, I guess, many, many years ago. Had the leash kind of wrapped around and something happened and this dog just tore ass off, and it got this part of his finger, like this ring finger, I think, and just took this part off from this joint forward. And it was gross. It was just horrendous. But then what was even stranger was it started to grow back. And at first it looked like a little baby finger coming back, or like a little, like it looked very small, very disproportionate. But then it grew back to like the full finger. It looked a little strange, but it was back to full. It was wild.
Human body's weird sometimes.
It is very
enough
weird.
Sidetracking. Sorry.
So I don't want to disagree with you, Dan, on this verdict, because I kind of have mixed feelings, right? Yes, your response when you're a police officer, when you're a law enforcement, and you have a job to do, and when you don't do it, there should be consequences. Okay, I agree with that. So then why aren't all the other officers that were involved in this not facing consequences as well? Well, because they didn't wait as long as this dude who was like there first. Like,
the police chief has the same charges. The guy who was running the scene.
Yeah,
he has the same charges.
I mean, but why not all the other officers too that didn't go in?
I don't know. Maybe they're waiting. Maybe they're testing it on the leader.
Maybe.
It could also be that through testimony the officers below him were objecting to it. I don't know.
Maybe.
But yeah, I mean, you raise a good point. Don't get me wrong. But I'm massively disturbed. Number one, I was disturbed at the time by the idea that these guys didn't go in. I'm sorry about your safety, dude. You took the job.
Yeah, it bothered me too. Yeah. It bothered me as well. I mean, and I don't think anybody, I get it. For me, I don't think I'd go in. If I was the only one there, I don't think I'd go in guns blazing, so to speak, or maybe quite literally, because I'm the only guy there and I don't necessarily know the situation. I just know that there's a guy shooting, but at the same time, if I signed up for the job, I mean, that's kind of what I'm supposed to do. Now, if he guns me down, that's not good. Obviously, that's not optimal, and I haven't done my job. But at the same time, that's one of those that it's life or death, not just for yourself, but for all those other children in there. And so I'm not saying that I'm not going to lose sleep that this guy was on trial. It's weird that he was found not guilty. I do think that's strange, especially due to the outrage that everybody seemed to have about it. Maybe the jury felt the same way. Like maybe the jury also felt, hey, it wasn't even about the facts. It's just like this guy they're kind of setting him up to be the fall guy. They're holding him solely responsible, him and the police chief, solely responsible when there was a bunch of other officers there that didn't do the job either for, what was it, over an hour? So
yeah,
this is one of those. He
was there straight away because that's where he was assigned.
Yeah, no, I get it, and again, school resource officer, you're supposed to be. That's like your one job. Like you protect the school.
Yeah,
but I there are mixed thoughts that I have on that whole situation. I guess obviously there's going to be. There's qualified immunity, yes, but there's probably civil liability still that could attach here, because qualified immunity is only going to get you so far when you grossly deviate, from your stated job, and it's basically dereliction of your duty as a police officer. Now, his not guilty verdict would probably go a long way to protect him from a lot of the civil liability, but who knows? Not that you'd probably get much from this guy, making a police officer's salary. What are you going to get? I mean, really, but still, there's probably going to be more litigation that this guy will face.
Yeah, I mean, undoubtedly, and it's not like the family's going to see any justice there either, because there's no doubt that this guy is not rich. I'm trying to figure out the how and the why that it ended up with a not guilty, because you look at other outcomes for police officers, and more often than not, a jury will do anything they can to nail him to the wall.
Sure.
I mean, you look at like the Derek Chauvin situation. He's got his knee on the neck of somebody who's chewing on a speedball and ODing, but he's got 18 consecutive life sentences for that, and I'm not disputing that. That was a bad look and a bad choice on his part, and I'm not here to debate that. But that's just an example of, we see a cop not doing their job properly and
Sure.
he's nailed to the wall. But you could argue that the guy's name slips my mind, but the one pinned to the ground, you can argue that he was not the greatest of people.
George Floyd.
He had a criminal record. George Floyd, thank you. He had a criminal record and all that. I'm not saying it made it right, but I'm saying you've got that contrasted with the innocence of a bunch of children.
Right.
And this guy is tasked with protecting them. He doesn't do the job or even try to do the job. And they're like, yeah, you're cool.
Right. If he got gunned down, he'd be a hero for at least trying. Now,
Yeah.
I'm sure some would, Monday morning quarterback and say, well, why didn't you wait for the other officers? And, we would have had that discussion. But I think that would have been a better discussion than, hey, why did they all stand around for an hour? Why, and that is the problem that I have with the whole case. Now, I do wonder, Dan, if the police chief, when it gets around to him, if the jury is going to be the same way, because now that's a leadership, right? That's higher up. Are they going to hold that guy accountable? Same set of facts, basically.
I would hope so. Somebody's got to be held accountable for that. It's one of the most wrong things that I remember seeing in recent years in law enforcement. We've had many wrong things. We've had a lot more right things that never make it to the media. So let's be clear about that before people accuse us of being overly political here, because I don't think that's the case. I think the vast majority of law enforcement really try to go and do their job to the best of their ability. I believe that, because the world isn't just filled with complete idiots.
Yeah.
However, the ones that get the press are the bad ones, and normally, like I said, when we see these situations, they're nailed to the wall, and this is not the case. But I hope there's some kind of accountability here, because this was just a horrible situation. Again, not the fact that the situation was there is not the fault of the officers. They didn't create the situation.
Sure.
But it's their job to respond to it.
Right.
Is it just me, or does it seem like one of the things we're losing in our society is that sense of honor and bravery?
I think, there's, it reminds me of your rant a couple of weeks ago, Dan, about strong men versus strong men. And I think we have a lot of guys that want to, they're strong men. They're keyboard warriors, or they talk tough, or they are tough when there's a bunch of them and somebody that they just want to bully. But when it comes, when the chips are down, when the crap is hitting the fan, these guys fold up like a JCPenney suit. And that's what I worry about. We need law enforcement to, not just enforce law, but to do so, especially in these critical situations where you have children that are at risk, that are literally getting killed right in front of you. And I think the Parkland shooting, there was a resource officer there too. Mm-hmm. And I think that guy didn't do his job either.
Yeah, if I recall correctly, there was issues with that as well.
Now that case is a little different, because it wasn't an hour or 70 minutes or whatever of waiting. It was still a delayed or an inadequate response. And, so this is not an isolated thing. This is not the first time that we've seen a situation like this where somebody didn't respond properly. And again, it's harder to, I know people will say, you're backseat driving this, your rear view mirror, your hindsight. But, and while that may be true, at the same time, these are police officers. That's what they're supposed to do. I mean, that's, I don't expect a teacher to try and tackle a gunman. I don't expect, the janitor to come rushing in or, we have resource officers on campus kind of for this reason. Kind of sad that we have to, but that's the world we live in. So do your job.
I'm going to disagree with you a little bit, Michael. I do kind of expect a janitor or a teacher to get in the mix if it comes to it. If a gunman charges into your classroom, you got to try. If for no other reason than you're going to take that bullet before the child does. Because there's a hierarchy to things. And that's part of, in my opinion anyways, being a proper human being. Is there are certain times where the good of the many outweighs the good of the few, or the one, to quote Spock in Star Trek. But it's true.
I see what you're saying, Dan.
There's a time where you've got to consider laying down your life. You have to try, knowing even that you might not walk away from it. And, I suppose you could say, well, that's easy for you to say, Dan. You've never had to do it. Well, the time may come, and I pray every day that I'll have the strength to do it, and I believe that I will. Because of the fact that I have morals and ethics and a priority system in my brain of what's most important. And if you've got a gunman charging into a classroom of 30 kids and you're the adult, the most important thing is doing anything possible to protect those kids. You charge at that guy, you grab a chair and throw it at him. I don't, grab your scissors and, chuck them like a knife and turn yourself into the bride from Kill Bill and just start something.
Two guys charged at the shooter at the Gabby Giffords event back in 2011 when the guy was reloading. He was going to go for, now he was reloading, but if you're trained, and especially if you have just multiple magazines on you, it does not take long to reload. And so these guys saw the opportunity, and they seized the moment and did the best. And had they not, I know people still died then, including a 9-year-old, and it was just terribly tragic. And Gabby Giffords is forever changed as a result of that. And it was just a horrible thing. But imagine how much worse it would have been, but for the bravery of two dudes, one of whom I believe was like in his 60s.
Yes.
And then another guy, like they just charged at the guy. And
as I recall too, one or both of them was actually armed at the time, but the better play was to just physically tackle. And that's what they went for.
Yeah.
Because by the time they got there, he was reloading. So that's what they did. So, I mean, they made some really good choices in the split second with what they had to work with. And, I'm not saying that back to the Uvalde situation, that if that officer had acted immediately, that there still would not have been death.
Sure. I think there may well have been.
Well, because at that point, that gunman has the jump on you. He's ahead. He's seconds ahead of you.
He wins initiative.
Have to try to catch up.
Yeah. Yep.
I don't know.
But
I saw that last night and my blood just started to boil because it says so many things about where we're at right now.
Well, and I know that, the larger conversation is, why is it like this in the first place? Why do we have so many school shootings? What is going on? Why is it that we're even having to have this discussion in the first place? Michelle and I were talking about how it seemed like 1999 was like this big turning point year for the U.S. and things really started to make this major change back in like 99. You had
culture stopped then.
Columbine happened. right there. It was also that was the same week I got hit by a car. But I mean, no, you had Columbine that happened right there. And then just kind of, that was this tone changer, I think. Not that school shootings never happened before Columbine, but that was like a big deal. And then we started to see this escalation in those, and then just everything just started to kind of go, sideways. Not to make an overly grandiose thing about it, but that's kind of how I look at that as a big turning point.
Yeah, no, I would agree. I think a lot of things turned in 1999. Just society in general. It's like we stopped building culture then. I don't know. I've never figured out specifically why. It's probably an internet thing. Because most things are.
I blame AOL.
Yeah, maybe.
But yeah,
I don't know.
It was, we were so busy worried about Y2K and all the computers crashing in the end of the world. But at the same time, what we weren't aware of was this big change in society. And I'm not saying that was that one event or even a couple of events from that year are the only things. There's many things that have happened throughout history that you can say were turning points of their own. But that was, I feel like, without sounding cheesy or hokey, I feel like we kind of lost a lot of innocence right after that. I don't know. Maybe I'm misreading that, but I really, when I look back at it, having the benefit of 27 years almost of hindsight, I kind of feel like that. And because, then we go into the 2000s and you have all these terror attacks and the USS Cole gets hit, and then a year later, 9/11, and then it kind of snowballs from there.
Okay. We lost everybody there for a minute.
Oh.
I had to switch to the backup internet.
Oh God.
So I don't know what you said.
Oh.
It was like right at the start of your statement there, it just everything cut.
I was going to say, Dan, I feel like at 1999, I feel like, it's cheesy and hokey as this may sound, I feel like Columbine, I think that was like the turning point where we sort of lost some of our innocence.
Yeah.
And then after that, we had the USS Cole that got attacked in like 2000. The terror attack started to ramp up, and then there was 9/11, and it just things it was like this snowball. And I don't know. I guess I just feel that that's kind of where things really started to turn weird. And now, for me personally and for the country, and just kind of in a weird, it was just a very strange. I know there was some good stuff in the 2000s, but I mean, it was just like there was this palpable turn. I don't know.
No, there really was. So Wahoo put in the chat a question I've never had a good answer to is, was there school shootings in the pioneer days? I will tell you that when my father was in school, it wasn't uncommon for a kid to be carrying a rifle around because they're going to go hunting after school.
That's my parents too. My dad, he was in North Dakota. People on their cars, they had rifles, shotguns. It was not an uncommon thing to have that on people's cars, gun racks and all that. I mean, that's hunting territory up there.
Yep. So I think to answer Wahoo's question, I don't think there were. Because that's just not the kind of crime that people would think of. I mean, even the robbers and the outlaws and all of that, unless history has been lying to us, they were most likely to ignore the children because that's not the target.
Yeah, I sort of feel that way as well. I always felt like schools were sort of these like off limits. The schools and churches And not to say that there weren't church burnings and all that sort of thing, because, there was a lot of it. But I mean, from the outlaws, from these gangsters, that seemed to be like they left that alone.
Well, there was an
So,
honor among thieves.
A little bit, I mean, sure, Al Capone would gun down anybody that looked at him the wrong way. Absolutely. But he's not going to go into a school and shoot all the children. I mean, there's a big difference.
Well, and they dress in their Sunday best to go do it too.
Yes.
And
why can't we at least have that back?
And back when bullets were apparently free, they'd be nice enough to shoot their name into the side of the bank after they were done robbing it.
Have a signature.
Yeah. Just so everybody knew who did it. There was a certain honor. It's like, yeah, this was me.
This is me. Come on, coppers. Catch me if you can.
I don't know.
Oh, doctor, this is firecrackers, I tell you.
I'm so confused by this world.
I am too. It's a weird place, Dan. One other thing, so I think we're still on page 12 of that lawyer's story about her client Veronica today. My goodness, that was a Paul Harvey rest of the story and beyond. Oh my goodness, I don't know if. This isn't necessarily a sidebar topic, but I will say, what relevance does her third grade teacher's dog or she was in the ballet when she was 5. What does that have to do with a crime that she's committed today or a crime that she committed recently?
Well, I suppose we could 6 degrees of separation it somehow.
Sure. Look,
it that way.
The part
I have no idea.
The part where Dad goes out for cigarettes in 1998 and doesn't come back. That part I get. That can be included. Sure. The part where, maybe they were, abused in various ways as children. That part can come in. Sure. But I mean, we were getting down into the weeds of when she was. And then when she was 10, she attended a baseball game at Synergy Field. And I was like, why are we, what are we getting down to here? We're breaking down like, she wrote a report on the Alamo in 4th grade. Her mother found the handwriting was sloppy and tore it up and had her redo it and say, this is how you're supposed to. It's like, why do we, I don't get it. This was like wild. So maybe we ought to start having a clock, just like we do for In the Blind. Let's put a clock on these
maybe
testimonies.
Well, it felt like a giant filibuster, and maybe I'm giving her credit here, but maybe that's what she was thinking. It's like I've
just
got
put
nothing
Mr. Prater to
here,
sleep.
so if I throw enough words at it, maybe one of them will stick.
Well, I was going to ask a question, but I done fell asleep during what you was talking about. So my vote is to grant because I don't want to hear another damn word.
Well, I don't know if you saw this, but when she was done talking, I applauded because I'm like, yay, it's done. And then I don't know if it was Prater or who, but one of them said, well, I've got some questions for you. I'm like,
It's like the kid that goes, hey, you forgot to sign us homework. That just as the bell is ringing.
yeah, that kid got beat up afterwards.
Oh, and deserved it. My God. And come on, Prater. The tick-tock, man, the clock is running out for you. How much longer do you have to live? You want to listen to this lady's story? You want publicity? Like this lady, this lawyer was, I mean, I'll give her this. I mean, that was quite the story.
Oh yeah.
I mean, I was zoning out for it, but I'd come back from time. I'm working on stuff, and I'm hearing this, and then I'm kind of going over to the chat, and I'm like, what is all this? So I was, it's still good stuff, but I just don't know. Maybe a 2-minute clock on these people would be good.
Well, they tell them that sometimes. They'll say, you've only got 3 minutes.
That's the thing too.
They're so all over the place. Like,
yeah,
the one that you had.
Oh
when I
my
was
God.
when I was in Montana at the time.
Yes.
And that actually got replayed on Monday.
Monday, yeah.
Yeah, it was part of the best of.
That was a
there.
great one.
That thing went on for like 42 hours. I don't
Yes.
know. I was happy that you were able to stick with it, but you must have been parched by the end of it.
You know what though? That was one I'm glad there wasn't a clock. I thought for sure they were going to cut it off, but I think we wanted to hear about the threesomes and the and then the drugs, and then we gonna tell the truth. And I was like, oh, okay, let's do it. Let's keep. I mean, that went way into over. I started that. If I remember right, it was like 10:20. I'm like, oh, let's go to the Louisiana Board of Pardons and Paroles, and I already had like a couple other places I wanted to go. That thing went to like 11:30, and I'm like,
yeah, no, it
I'm
was like
getting
an
hungry.
hour 20, hour 40, something like that.
It's like lunchtime. Come on. This was that was like the wildest hearing I've ever sat in for.
There was an executive session in that one too.
There was.
You had to go someplace else for a while you were waiting.
Yes. Yeah, because that wasn't in the way back either. That was pretty much live, almost live. So I was like, well, let's go to Judge Boyd, or let's go to somebody, and then we'll come back for that. Yeah, that was the other thing is I was like, man, it's not over. So that was an insane hearing. Those guys are all over the place.
They I think enjoyed the salaciousness of that one. They were just like, yeah, we need this.
When it's just stuff like, oh, and then, when he was 12, he broke, he got an F on his history. They're like, all right, now we gonna need you to move this along. I ain't got much more time to live, so I'm gonna ask you to limit your comments to 12 seconds.
Mm-hmm. As opposed to, wait a minute, did you say threesome?
Wait a minute
Tell
now.
me more.
Hold on a second. Let me just jot this down.
Did you bring photographs?
We gonna need just pics, or it didn't happen.
Now, you said there were security cameras in the home, yes? And there were, if you'll recall.
Yeah. I'm like, there is evidence that has got to be somewhere, and I'm just wondering, that's all going to come out eventually. It's all going to be somebody's going to file a Freedom of Information Act on that. In fact, I'm going to draft that up right now. Doesn't matter.
Get Eli to do it.
Yeah. Get the paperwork going.
We didn't find out about it until later on when he told us this, but Eli at like age 9 filed a FOIA request for something.
Wow.
And he got it.
Wow.
I know. And then he told us later.
Dan, you must have been so proud.
Well, we're like, how did you get this information? He's like, I filed a FOIA. And I'm like, you did what?
How would you know what that is? You're 9.
Oh, my kid's insane.
I was weird at 9. Don't get me wrong. I was like listening to talk radio and stuff. Like, I did things that were unusual at 9, but even I wouldn't have been like, oh yeah, I'll file a Freedom of Information Act. I want to see about this Iran-Contra thing a little bit more. Like, what?
Well, we were talking the other night with him about like future plans, and because he's 17 now, so starting to think about where we want to craft our future. And he's like, I'm not that worried about it. He's like, I've got a couple of people in Silicon Valley that owe me a favor. And I'm like, what are you talking about? What? And then he gives us this big dissertation about how he helped these people figure out what was wrong with their server. I'm like, really? And he's like, yeah, here's what I did. And he listed the whole thing out. And I'm like, you were insane.
Father, I'm not worried about it. I've invented a time machine. I can't be bothered with all of this palaver about college and university and whatnot.
You know what? It wouldn't surprise me.
I tell you. Dan, that's something else that you got going on over there. Good for you. I mean, man.
Oh, good or
talk about hitting a home run. Hit grand slam.
Yeah. I don't know.
I'll just take over your channel, Dad. It'll be, Courtroom Files will be a generational thing.
Yeah. Maybe. You never know. I don't know.
Yeah.
Kid is,
I don't know, Dan.
Wild,
That's
man.
That's great. That's great news. Well, good for you, man. It must have been a proud moment. So I'm glad.
Proud and confusing.
Yeah. Well, I'm excited for the new show.
Yeah.
Tonight, maybe
in just a few minutes.
Yes. Tonight, maybe I'll pop in for a sidebar. I've got a meeting, so, you know.
Well, you can always join us. We'll hold down the fort. It won't be quite the same without you, but
yeah,
maybe I'll put up a still image of you.
Well, there you go.
Just to keep us company. That might be a good idea. Maybe we'll do that.
Soundboard, just me just randomly laughing at inappropriate things.
Well, isn't that what we pretty much do anyways?
That's pretty much, you know, just throwing in a random inappropriate comment or, you know, that's pretty much what I do. That's my
one
role.
Spoiler alert, within like the first 4 minutes, I made a pretty inappropriate comment.
Oh, and In the Blind? Yeah, and then I followed it up.
You did.
You know.
Yes.
Yeah, Dan was like, well, just make sure you don't do anything to get us banned. And then Dan does something.
I don't think it gets us banned.
Well, no, but, you know, you're like, hey, we have to be on our best behavior here.
Well, I don't think it would have made us ad friendly, but we're not monetized over there yet. So it doesn't matter.
No, right, of course. Hey, it doesn't bother me at all. I just, you know, to me.
Well, no, you played right along.
Well, yeah.
You were all like, no, here's where you're wrong. Here's what you really need.
Of course. That's the show. That's the beauty of this show. And you guys will see it. I would say of all the, you know, and I've done various shows over the years. This was, of all the first shows I've done, this one was really the best. It's the most fun.
Not perfect. We had a couple of growing pains.
No. There's,
I think it's cool.
Tech issues are tech issues. It doesn't matter how long you've done this. That's always the problem.
Yeah. Well, even that was pretty light. I mean, we did it in one take without blowing anything up, so it was pretty good.
Yeah, no, we didn't have to stop and come back, and which again was a great sign. I didn't think that was going to happen anyway, but that's why we pre-recorded anyway. Just be sure, you know, something didn't go wrong. That you know what that means though is on February 2nd when the show premieres live, we're gonna get something's gonna blow up.
Oh yeah, fully expect it. But that's the whole idea.
Like a tornado will plow through the neighborhood. Something is going to happen on that live show. But that's why we do things live. I used to do my weather videos live because you never knew what was going to happen. You know, I had my green screen fall down on my head once during the live weather. A lot of things happened. The dog, you know, Topaz just came up and jumped right up on my lap once. And, you know, a lot of things can happen in a live show. So that's the beauty of it. That's why we're doing it.
So it makes it so much fun.
Yes.
All right, Mikey. Well, let's end this so they can be sent over there and get ready for it. Yeah.
Absolutely, sir.
You going to join us in the chat?
I will be there.
All right. See ya.
See ya.
All right, my friends, if you want to watch In the Blind, just stick right where you are because YouTube should direct you over there. See, there's a little In the Blind logo right there because I clicked on the wrong thing in the top right. That's what it looks like. All right, there we go. Anyways, that's coming your way in just a few minutes, so enjoy it. Give us feedback in the chat. Let us know what you think because we did have a lot of fun with this and we want to make it something special, so help us make it something special, and we'd really appreciate that. But we'll be back tomorrow here at TCF, 9 a.m. Eastern, 6 a.m. Pacific, and then tonight for Sidebar right here, 8 p.m. East, 5 Pacific. So see you guys over at In the Blind. Hang tight. Don't go away.